Commissioner Kopp.
Here.
Commissioner Rennie.
Present.
Commissioner Lee.
Here.
Commissioner Ambrose.
Here.
Okay. Agenda item number 2, public comment on matters appearing or not appearing on the agenda.
Good afternoon. My name is Ellen Lee Zhao. I am a public social worker for Department of Public Health. I have been coming here for many times to report government corruption. The last time I was in here, it was March 16, 2018. Today, I am here to request ethics commissions to review the election process. As you know or may not know, I was one of the 8 male candidates for mayor for the June 5th election. During the election, I was not allowed to join more than 20 mayor candidate debates or forums. At one point, 10 police was called to make sure that our team was not allowed to go inside for debate. For example, at 401 Van Ness, a public building, I was not allowed to participate, and there were so many candidates inside, I was not allowed to introduce myself as a mayor candidate, and there's more than 400 audience inside. The other one, there was more than 1,000 people inside and possible voters. Many of those events organized by nonprofit organizations. And many of those forum events took place, public library, public recreational buildings. And I am here today to ask you to take a look at our election process. Our city should not be support corruption, election corruption, and it's not fair election. I was bullied and my team was being discriminated because we were not white people. And during the election, many of this forum and debate provide misleading information to our voters and to our public. Our public was misinformed, and it was not only misled to our public, but also a violation for fair election. We all pay $6,500 for the mail application to run for mayor. We should not be support corruption as a government entity. I am here today to ask you, ethics commissioners, to evaluate our election process. All candidates should be allowed to participate in public-owned buildings and public entities, such as public library, recreational center, and 401 Van Ness, and City Hall. There's one of the forum inside City Hall, and we were not allowed to come and debate. And our city should not be controlled by people with money. And we have Jeffrey Spear here today. I have encountered him many times. I was told the Ethics Commission's department will not intervene because it is allowed by the law. I call it's corruption. I came in here many, many times to report government election. I am a bargaining team as a union substore for public employees, and we knew from the bottom to top, corruption is covered by top. So I'm here today to ask you also to take a look at our election process for the way the matching fund has been spent, abuse government resources. And for the time's sake, I'm giving you my copy, my name, and the complaint that I have. And we have Jeffrey Spear in here, which I have been working so many times, and Leanne right here. And thank you.
Thank you.
Hello, Commissioners. I'm Tony Kelly, and I'm a candidate over in District 10 for the supervisor race over there. I have a different concern, slightly different concern about the matching funds process. That's not on your agenda today, but I think you may find that it's related when you discussed in your consideration of the appeals. So my campaign submitted our qualifying request for matching funds on the first day we were allowed to do so, February 6th. We had the proper forms in, we had the statement of participation in at the same time, followed all the rules. We never got a response ever. I'm still waiting for the first response from the Ethics Department considering our request and then denying it and wanting to follow up on a certain number of contributions. We never got that letter. I had to notice while looking at other things at the ethics website in May that other candidates had actually received responses and were turning in revised submissions to find out that it was even possible to do it. And we were trying to give the department a break because, of course, it was a crazy mayor's race and a lot of things were going on about many matching funds requests. But okay, but at least tell us what's going on. So we finally turned in a revised submission in May, which then took almost the full 30 days to then deny that request and need to follow up on a whole number of what I would consider to be fairly bureaucratic things, because I've been through this before. I've run as a candidate twice before with volunteer treasurers and professional treasurers and had no problem, nothing like on this scale, about how much follow-up is needed or how much revision is needed, how many different submissions you have to do. This morning, just a couple hours ago, we received our third declination of eligibility and saying we need follow-up on things. Looking at the spreadsheet for a quick review of it, there are now contributions that need follow-up that did not need follow-up before that were accepted. And we're getting references to different parts of code, like, oh, we need to turn this in now too. So look, fair enough. First, I'm very happy that the staff responded to the second submission so promptly. We're now not getting a 30 days wait for a response. It's now happening within a week or two. So that's an improvement, and I want to give the staff credit for that. We're happy to work with them. We want to turn in the things that it's appropriate and want to follow the rules. But there's something this year that is much more difficult about this process than it's ever been. And something there's been a lack of communication from staff to us in the campaigns, and we just need to get some improvement in that kind of transparency and that kind of contact to do it. Because none of us are trying to mess this up, none of us are trying to jam it up, and we're now at a point late in the campaign, the reason we turned ours in so early was because we budgeted for a certain cash flow. I'm trying to work this out. We are hiring staff, we're knocking on thousands of doors, we're trying to communicate a campaign, and we're spending more time trying to get through this bureaucracy than actually trying to talk to voters. That seems to get a little bit confused about the process. So this is more frustration than anything else. We'll turn on submission number 4 early next week, and we hope that'll go fine, and I'm looking up at all the state laws to make sure, because we're not getting the full information from the ethics department. So just confessing some frustration to that, and wanted to meet with staff. I went down to meet with staff, and they said they were all up. Yeah. Thanks so much.
Thank you.
If there isn't any other public comment, I want to go back to Ms. Chen's statement through the chair to the staff. Is anybody aware of the fact that Ms. Chen or anyone else couldn't get into what I understood from her as a standard informational meeting for candidates?
Yeah, thank you, Commissioner Kopp. Staff were aware. The allegations respect candidate forums or candidate debates, and nothing in local or state law would empower the Ethics Commission to require that nonprofits invite certain candidates to those events.
Well, that's self-evident. Is that what she's referring to, and not to Ethics Commission sponsored informational session?
It was not an informational session. It was, in fact, a candidate debate.
Through the chair to Ms. Chen, that's up to whoever sponsors the event that you couldn't get into. It's not up to the Ethics Commission.
Thank you.
Excuse me, that was not the point. The point is that the government buildings and entities should not allow any candidates to organize forums, but does not allow candidates to go in. That
Okay.
was the main point. Correction.
Thank you. Agenda item number 3 on the consent calendar. We'll call for public comment. There being no public comment, is there a motion to approve the draft minutes for the June 15th? Is there a second?
Second.
There's a second. All in favor?
Aye.
Aye. Opposed? Motion is carried unanimously and the minutes are approved. Agenda item number 4, discussion and possible action on proposed stipulation, decision, and order in the matter of Unite Here Local 2, Ethics Commission case number 1617-127.
Thank you, Chair Chu and Commissioners. Briefly, as you know, we have a new process under the enforcement regulations that came into effect this spring. Stipulations might appear on a consent calendar, proposed stipulations, that is, unless a commissioner requests that they be pulled from the calendar for consideration at a commission meeting. That is the case here. With agenda item 4, Commissioner Kopp requested that the commission have an opportunity to discuss the proposed stipulation before you. You have a couple of options. You can approve the proposed stipulation as staff has secured it with the respondent committee, or if you prefer not to approve the stipulation, you can provide guidance to staff on what sort of a settlement you think would be more appropriate. But in brief, this concerned a committee that failed to timely file, or rather that omitted to file, 2 late contribution reports, 2 Form 497s. Enforcement staff learned of those omissions as a result of an audit that commission audit staff conducted. One of those late contributions came from the fall of 2014 and the other from the fall of 2015. The contributions were, however, reported on timely filed Forms 460, and so the information was available to the public, but not within 24 hours, as the Political Reform Act requires. Staff brought 2 counts, one for each of those omitted filings, and negotiated the attached settlement with the committee. The penalty amount, as you see, is $27.50 for each of the counts. I believe that's right, $27.50, totaling $5,100, which comes out to, I believe, $5,500. Sorry, thanks. Which comes out to, I believe, 60% of the unreported amount. As you know, the enforcement regulations set out factors that guide staff in evaluating what penalty might be fair. Those factors are enumerated for you on, let's see, page 3 of the exhibit. But in short, staff determined that $27.50 per count would be a fair amount of liability in this instance because of a history of late penalty assessments, not omitted filings, but late filings on the part of this committee. But in mitigation, the committee cooperated with the investigation. We have no evidence that these omissions were willful, and as I mentioned, the information that these omitted forms would have reported was otherwise available to the public via a Form 460. We did, in addition, compare this negotiated settlement to other settlements that the Commission has negotiated. There were no perfectly analogous fact patterns, but in comparison to other settlements that we've negotiated with respondents, staff thought that this would be strong enough to provide a deterrent effect, but also at the same time consistent with other settlements and fair to the respondents in light of the mitigation.
Thank you, Mr. Pierce. I have a question regarding the committee's more recent filings. So you indicate there is a history of late filing starting in 2012, and the filings at issue here are in 2014 and 2015. Has the committee been timely in its filings for the 2016, 17, and 18 elections?
I believe there may have been one late filing in 2016, but they have been timely in both 2017 and 2018.
Thank you. Commissioner Kopp?
Yes, I have some questions. Looking at the exhibit, page 2, there's a reference to the fact, and I quote from it, the committee has a history of late penalty assessments for filing campaign statements. From a few days after their deadlines and upon written notification from the Commission of delinquent filings. So you start with October 2012. What was the late penalty assessed for that violation?
The Commission has a late fines collection officer, and that individual assesses late penalties against.
I asked for the amount.
The amount is defined by statute, so it's $25 a day, up to.
I'm sorry.
I don't know the. I don't know
What
the.
was the amount of the penalty in that instance?
I do not know offhand, but I'm happy to learn that information.
Please, I would like to know. It then refers to.
Commissioner Kopp, if I may, it turns out the respondent is here, or a representative for the respondent.
If I may, thank you, Commissioners. I'm Ian Lewis. I'm the Assistant Treasurer for the Unite Here Local 2 PAC and also responsible for the reporting. As staff said, there were the 2 late filings. There was no intent to conceal here. We made a mistake.
I didn't ask for a speech. I want an amount. Do you know the amount?
$229.50.
How much?
$229.50.
All right. And then, since you appear to have information, the next one was September of 2015, a late penalty on the FPPC form. All right. What was that amount?
I do not have that amount with me.
All right. May I get that amount from staff?
Yes.
And then I don't know about this. Apparently in February 2016, another late penalty. Does staff know what that amount was?
No, not offhand.
Well, I know other people want to testify, but Madam Chairwoman, I'm inclined to make a motion to postpone this until our next meeting so that that information, which is relevant, can be obtained.
Before anyone might second that, the
No, other people may want to testify, and they came here, and after they testify, it's my intent to make that motion.
I have an answer to your questions, Commissioner Cobb.
All right, then, what are they?
The 2016 late penalty was $425, and the September 2015 late penalty was $75.
7,000?
75.
75.
Sorry, late fees.
$75. $75.
And the first one was 269?
$229.50.
$229. Okay, thank you.
Other questions at all from commissioners? Mr. Lewis, I had one question for you. In the stipulation or in our materials here, you say that you'll do your best not to let this happen again. What concrete steps have you taken to ensure that these filings are going to be timely made on a go-forward basis?
Thank you, Commissioner. I myself, after these problems in the 2014-15 cycle were identified, attended a training. We have also retained legal counsel to provide us advice. This period of time coincided with, or the 2012 violations rather, coincided with a shift to electronic filing, which was unfamiliar to us. To provide some color to the other violations, for example, the 2012 violations were mostly cases where we filed by paper and not electronically as we were obligated to, or we filed on the wrong form. The 2016 violation was an in-kind contribution that put us over the $1,000 reporting mark, which was something we did not identify until we did a fair market value calculation. These are cases, they're violations. We think the penalties, as the stipulation here is, are appropriate. But we don't think that we have ever done anything intentional, certainly never done anything intentional or egregious, frankly, in disclosing our activities.
Thank you. Commissioner Kopp, do you have anything else for Mr. Lewis?
I have no questions.
Okay. Public comment?
Of that, witness.
No public comment. Did you want to make did you want to make a motion? There's no public comment.
Is there public comment?
There's no public comment.
All right. The reason I removed this from the consent calendar should be obvious. And the facts are even more pronounced than the summary of material facts discloses. That summary makes the accurate statement, quote, "The committee has a history of late penalty assessments for filing campaign statements and from a few days after their deadlines and upon written notification from the Commission of Delinquent Filings." On page 3, the staff makes the further comment, applying the penalty factors enumerated above, the respondent's violation is significant because as a committee, active since 2002, that's 16 years ago, it has a history of late penalty assessments with the commission, and it knew or should have known it was required to report late contributions within 24 hours of the time they were made. And the record now shows a prior fine of $75 for a violation after a first violation fine of $229, and then a third violation of $425. This proposed stipulation represents nothing more than a slap on the wrist. I will not vote to approve any stipulation which is less than $13,000 for this, the fourth disclosed violation within the last 6 years. And I discerned that there is no sense making a motion to amend a proposed stipulation, which takes two to tango, so to speak, but to send this back to the staff to negotiate further with the respondent, or to bring it to the commission at a subsequent meeting for action.
I have a clarifying question for Mr. Pierce. What is the maximum amount of the penalty for these two violations?
Well, it's, the ordinance provides that it is $5,000 per violation or 3 times the amount unreported, so that would be
$27,300.
Let me see. So, Commissioner Kopp, that your guidance to, as a commissioner would be to seek a penalty of $13,000 for these two violations?
Yes.
$13,000. I turn to my fellow commissioners. Is there a desire to support this action, or to approve the order as written here, as negotiated between staff and the respondent?
Although I'm troubled by the history of violations, I would move that we accept and authorize the executive director to enter into this stipulated settlement.
And I have a clarifying question. Did I hear correctly that this committee, while they had numerous violations prior to 2016, prior to 2016, that they have not violated our regulations in 2016 and 17?
I was unsure about 2016. I think there may have been one. I don't want to misrepresent the respondent, but certainly in 2017 and 2018, they have complied. And they have had no other enforcement matters with the commission. And I would like to clarify that the facts enumerated in section 2 at the top of page 2, the stipulation says late penalty assessments, but to be clear, those are governed by ordinance, and they were not the result of an investigation or an enforcement action. Those are handled as late filing fees. The ordinance provides that the cost for that for electronic filings is $25 a day, and that $25 is limited. The total liability is limited either to $250 or to the amount of unreported activity, whichever is greater. So that's why you're seeing prior penalties, which we would call fees, at $75 or $425, because it's simply $25 times the number of days late. So we have treated this omission differently than we have treated late filings in the past, because the ordinance governs what late filings look like.
All right, well, thank you for that clarifying detail. But I guess the point, I would be prepared to support Commissioner Rennie's motion in consideration of the fact that they seem to have gotten their act together and have not had any violations in the last 2 years. I would support the staff recommendation.
So I take that as a second, Commissioner Ambrose?
Correct.
Okay. All right. So we have a motion by Commissioner Rennie and seconded by Commissioner Ambrose to approve the stipulation and at the settlement amounts reached between staff and Unite Here Local 2. All in favor?
Aye.
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 Opposed?
No.
The motion is approved 4-1. Agenda item number 5, discussion and possible action regarding request for waiver of post-service employment restriction by former Supervisor Jeff Sheehy.
Thank you, Commissioners. Pat Ford, Senior Policy Analyst. This agenda item represents a request by former Supervisor Jeff Sheehy for a waiver from a particular provision of the Campaign and Governmental Conduct Code. As you know, Mr. Sheehy was a supervisor representing District 8 until earlier this month when Raphael Mandelman was sworn in. But Mr. Sheehy did serve on the board and until July. And he therefore is subject to a provision of the code which essentially states that if a city officer participates substantially and personally in awarding a contract, then for 12 months after the time that that contract is awarded, that the city officer shall not be employed or receive compensation from an organization that's a party to the contract. Essentially, in this case, Supervisor Sheehy has asked for a waiver from this provision of the code so that he can seek employment from the University of California. And the University of California is a party to 3 contracts that were approved by the board during Mr. Sheehy's tenure on the board. And he voted on the contracts, and thus he participated personally and substantially, so the provision is clearly triggered and would apply to him if a waiver is not issued. It would prevent him from receiving compensation from the University of California. So in staff's memo that's here attached to item 5, you'll see former Supervisor Sheehy's memo that he wrote explaining why he believes a waiver is necessary, and he included some attachments that basically show his involvement with these contracts. And in staff's memo for agenda item 5, I basically just gave an overview of what the law is here and how it applies, given the facts that Mr. Sheehy states in his memo. But I will leave it to your discretion as to whether or not a waiver is proper. Staff did not include a recommendation, yay or nay, whether a waiver should be issued. I did, however, include a recommendation in the final paragraph that if the commission does decide to approve a waiver, that it basically be tailored to the facts of Mr. Sheehy's memo and to his request. Essentially, he's speaking about one position in particular that he believes he would experience extreme hardship if he were not able to pursue this position. So my recommendation would be that the waiver, if you decide to issue one, would essentially be tailored to that position, since this is what he's expressed his interest in. So I will make myself available for questions if you have any, and otherwise I believe Mr. Sheehy is here and would like to speak on this.
Commissioner Comp?
I want to confirm through the chair the recommendation of the commission that a waiver be granted with the condition that such waiver be for the position described by Mr. Sheehy.
So no, staff's recommendation is not expressly that a waiver be granted.
Pardon me?
No, I have not included a recommendation in this memo as to whether or not.
Oh, that's
waiver
right.
should
You
be-
said if the commission does grant the
Correct.
exemption,
Correct.
that
The
it be
determination-
specified, it be for the one position which Mr. Sheehy, for personal and policy reasons, didn't identify, but said that he would identify if the commission wanted it. Is that accurate?
That's correct. Yeah, the
It would be
assessment is
for
very
that
fact-intensive.
specific position.
Correct.
All right, thank you.
No, it's correct, is it not, that the 3 contracts that are referred to, 2 of them are settlements of lawsuits where the University of California was paying money and the city of San Francisco was paying money to dispose of it. Is that correct?
That is correct.
And there was no continuing sort of benefit to the University of California or to the city of San Francisco other than they got rid of a lawsuit.
That's correct.
2 of them. And the third one was a resolution to allow the health department to receive a grant from the University of California.
That's right.
And again, there was no benefit being conferred by the agreement that the Board of Supervisors was entering into that would benefit the University of California.
Yes.
Is that correct?
That's right.
Why, assuming that, why then, if we decided to grant a waiver, should we carve out just this position? Why not, it could be any position at the University of California. Doesn't the rationale apply to all of the University of California?
So the rationale for whether or not those contracts create a danger of undue influence, favoritism, or preferential treatment, arguably they're the same regardless of the position, arguably, because the contracts are of a similar nature and it doesn't matter exactly what position the city officer attains afterwards. However, the primary factor that the code specifies the commission should be looking at is the likelihood of extreme hardship. That's actually the standard that is expressly set out in the code, that if a waiver to this particular provision is issued, that's why the commission should issue it.
But as I understand, part of the hardship is that if he's deprived of employment by the University of California, he loses the possibility of the 17 years that he worked at the University of California and accruing benefits that if he, say, finished 3 more years, so it's really the employment by the University of California, the deprivation of that, which is the penalty or the prejudice that he suffered, would it not?
I think it's absolutely a factor, and I included that in the memo, that his inability to finish out the 20 years of service is something that contributes to hardship. I absolutely agree. I saw many other factors in here that Supervisor Sheehy stated, So looking at it in the totality, I found that a lot of them were tailored to this particular position and to his desire to pursue a particular field, that's why there was such an intense hardship on him. And that's why I included that, because it seemed to be the thrust of his request here.
Thank you.
Any other questions, commissioners?
I think following along the line of Commissioner Rennie's questioning, if we were to limit it to the position yet to be identified, I guess my concern is because we've canceled the meeting in August, we would create an unnecessary hardship in waiting until maybe there's a different position and bringing it before the commission in September. And so for that same reason, I looking at the actions on University of California matters also take into consideration that there doesn't seem to be in actuality any participation in something that was to the benefit of the university or sort of anticipation of being hired back from them. And so I would be inclined to, once we hear public comment, to make a motion to authorize an University of California employment without coming back for a further waiver action. But that's my sense, unless we hear something else.
Commissioner Lee?
Hi, Madam Chair. I just have a question. Do you know if the position that the supervisor was mentioning, was he offered a position or is he in competition for the position? What's the status of that?
I don't know specifically. I think Supervisor Sheehy can answer that.
Okay. So is that an open competition position?
As far as I know from his communication to us, it's open at this time. I don't know the extent of his communications with the University of California regarding the position. You could ask him.
Okay.
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 Thank you. Supervisor Sheehy?
Thank you, Commissioners. And I don't know if you want me to make a statement or answer questions. I will tell you, I can give you a little bit of the history of this. I was not aware a conflict existed, and I, obviously on my way out the door, saw this position and applied for it. It's open. I've yet to interview for this position, but out of an abundance of caution, I have been discussing with City Attorney John Givner any opportunities that I'm looking at, and this really was going back to UC. This is what I've been doing for the last 17 years. I've been working in HIV/AIDS for 20 years, and I stopped looking at any additional positions at UC because of the waiver. This process is new to me. I was very grateful to Mayor Lee for the great honor of being appointed. I did not go into this with anticipation of what I would do next. I suppose when I talked to Mr. Givner and he informed me that this conflict existed, then I looked at it and I basically put everything on hold in terms of trying to get back to doing the work that I have been doing and something that is very important to me on a personal basis. So I was a little surprised because I did not recollect any major votes around anything related to UC when he communicated back to me that this conflict existed and advised me to seek a waiver from this commission, from this body. And so just in terms, I do want to elaborate on the hardship. It's not just the 17 years that I have there. I'm a 61-year-old person living with HIV. The point that I have HIV is something, and again, I'm grateful to Mayor Lee for making that historic decision, but let's be honest, stigma still exists. It is a chronic, life-threatening disease. I do think it provides real obstacles to getting employed in the private sector, where, you don't usually see private sector employers actively recruiting people with deadly chronic diseases. that their insurance would carry the burden of. Likewise, within the within the UC construct, there are very good disability benefits. There are very good life insurance benefits. I have a family, and health benefits as well. I provide health benefits to my husband and my daughter. My husband is an independent contractor and does not receive health benefits through his work. So what I'm trying to do is do the right thing. And I did notice in past instances people came here when they actually had a job, but I didn't have a high comfort level and wasn't sure how one proceeds in seeking an opportunity without the ability to actually take the opportunity pending a decision by this body. So again, in an abundance of caution, I wanted to clear or obtain a waiver if that is possible before proceeding with any other discussions with UC. But this has been my career.
Commissioner
I
Kopp?
want to ask you a question? Okay. I think you answered Commissioner Lee's question. You don't have an offer for this particular position.
I have yet to interview.
Okay. So logically, any grant of an exemption should not be limited to this position, as Mr. Rennie pointed out. Right?
In discussions with Ms. Pelham, I'm led to understand that for every position that I might seek to get at UC, if this waiver is limited, would require me to come back to this body.
All right. Well, the question posed to the commission then, which recommends against the grant based on, I don't know, precedent, which with the history of this commission before 2016 to me is worthless, is conditioned upon the last paragraph of the staff report, where Mr. Ford discusses and concludes that any waiver should not allow Supervisor Sheehy to obtain compensation from UC in any other capacity than this particular position. But Supervisor Sheehy, now Mr. Sheehy, does not have assurance of this particular position, but he has 17 years of employment by the University of California, and that leads to the possibility of pension after retirement. And he has performed duties which I infer are relevant to the particular position for which he's applied. And that position will be filled by the time the 3 years has expired, all of which leads me, I know, Madam Chairwoman, there'll be other potential witnesses, to be prepared to make a motion to grant the application for an exemption without a condition of obtaining the specific unidentified but identifiable as needed position at the University of California. And the only caveat I would attach to such a motion is a bar against participating in transactions or dealings with the city and county during that period of time, which satisfies one of the staff identified purposes of this rule.
I believe that would be covered under the code already. I believe that those restrictions would be covered under the code already, the post-employment restrictions.
If I could make a point, I specifically did not ask for a waiver for that. I did observe per Ms. Pelham, a predecessor who found themselves in the same state, and I noticed that they had sought exemption from that other rule. And so maybe that was an omission not to state clearly in our submission that we were in no way seeking a waiver from that provision.
So, Supervisor Sheehy, just a question about the role that you're seeking. Will there be any intersection in the work that you'll be doing as an HIV advocate and for patients as well as medical research with the city and any programs that the city is running?
I'm not sure I understand the question.
In this role that you hope to take on at UC, will you be interacting with San Francisco city programs in the area of HIV where your contacts or your experience as a supervisor would be engaged?
Not where my experience as a supervisor, but you have to understand the HIV enterprise in San Francisco. San Francisco General, which has Ward 86, the first HIV clinic, outpatient clinic established in the country, has been staffed by UC docs since its beginning. So, but again, I don't know if that's the test here, whether there will be interactions. There certainly wouldn't be interactions that rely on my role as a supervisor, nor would there be contacts that are trying to get resources to go from the city to the UC. But when you're at Ward 86, the doctor may be from UC, the nurse may be from UC, the social worker may be from DPH. It's been my experience is that it's a melange of it's a common enterprise that both the city and UC have taken on together. But I don't intend to use anything that, this is the work that I did before.
Okay, thank you. Commissioner Lee?
Thank you, Madam Chair. I just have a couple of questions for the supervisor. If the commission were to grant this waiver, it would be based on extreme hardship. So if for whatever reason you did not get this position and something else came up similar to your position, so for the director, will the supervisor be required to come back here for another request for the waiver? If it's not for this position, because right now if we were to grant the waiver and for this specific position that he is applying for, that he hasn't been offered yet, if he did not get this position but he's applied for another position, would he be required to come back?
If a waiver were specifically tailored only to this one position,
Okay.
then yes. If Mr. Sheehy wanted to then obtain compensation in a different position with the University of California, it would be outside the scope of that waiver, so he would need to get a separate waiver.
Okay. So, Madam Chair, I'd like to recommend that if we were to grant this waiver, it would be in the general term, not a specific position that we don't know yet what that position is, but if we could craft it in such a way that is similar to your background, that you're looking for a certain classification of health education, research position, so that if you are applying for something similar, you don't have to come back and we don't have to review this, with the caveat that if that position requires you to engage with city departments or whatever, that you would need to be recusing yourself from doing that during the period.
Okay.
Well, as I understand, he would only have to come back. I mean, if we granted a waiver to anything at UC, he would only have to come back if he was seeking a position at some other entity where he's told that he had voted on legislation. It's only because these three things dealt with the University of California. He doesn't need a waiver to go work for some private employer if that private employer has never.
Yeah, I meant within UC. I meant within UC. So if we can tailor it into any position that you would be applying for within the UC system, in the same classification of the health research and education positions that you're seeking. So I'm not talking about private,
right, now,
I'm
is
talking
that-
about
is
within
that-
UC.
Your
I
understanding?
was actually, I think along the lines that Commissioner Rennie was saying is, given the limitations of time and that he's still seeking positions, that we were prepared to make a motion that any position at UC he would be eligible for under the waiver. And I think along what Commissioner Kopp was saying, but he will still be subject to the other limitations on post-supervisor's employment. He won't be able to pick up the phone and call the president of the Board of Supervisors and get an expedited, I mean, he will comply with all the code requirements. He's only getting a waiver for working at the University of California. And I think that was collectively the motion that we've been discussing, but no one's yet made.
Thank you.
So that would be the motion.
Yeah, and since I wasn't the original author, you feel free to have someone else say it out loud. I think it was Commissioner Kopp who laid out that.
Well, I'll wait till comment.
Good point. Yeah. Right. We've talked about it for so long, we forgot about
So,
public comment.
do we have any other questions for Supervisor Sheehy or for Pat Ford? No? Okay. Thank you, Supervisor Sheehy, and I'll invite public comment at this time.
Good afternoon, commissioners, not supervisors. I'm Charlie Marsteller for the record, and I would join Mr. Bush in his comments of support for Mr. Sheehy's waiver. I myself worked in this field of HIV at UCSF for many years, and I know the system quite well, and I can assure you that his supervisors will be very sensitive to these issues. I think they'll be very pleased that he has been very forward and upfront about this issue, and I'm sure he'll discuss this in his interviews and even present to them maybe even his packet so that they can clearly understand the issues. And I'm sure his supervisors at UCSF will be very conscious and very cautious about putting him in an area where he would be in conflict. So I think we can count on UC's bureaucracy to really keep a good hold on the system of ethics. And I'm just relieved that there are no contracts pertaining to Russia, since we've seen so much of those in the news of late. So I congratulate him on finding an excellent position at UCSF. I hope it comes through and that he can continue his work there, and that those benefits do continue to accrue to him as well they should. I do want to also say that I think we owe him, on an aside here, thanks for his service to the city and for his hard work. And I'm sure that his work is extremely valued at UCSF and that he'll be promptly hired. Thank you.
Thank you. Any other public comment? No. So,
Madam Chairwoman,
Commissioner Kopp.
I'll move the application be granted for exemption of Mr. Sheehy from the 3-year ban on employment with any entity in which he participated as a member of the Board of Supervisors in approval of contracts, and that it not be limited to the position for which he has applied at UCSF, but that it applied to any position at UCSF.
If I could add two things. One is the code also requires that the commission make a finding that extreme hardship.
All right, I find that there is extreme hardship, and my motion is based upon a finding of extreme hardship. And I don't know whether the code requires it, but it's also based upon the fact that his participation in 3 contracts, which didn't cost San Francisco taxpayers any money, as Mr. Rennie has observed, is part of the rationale for my motion.
If I could add 2 other things, just to clarify, it's not a 3-year ban. The ban is a 12-month ban from the time that the contract is approved. And also, Mr. Sheehy hasn't requested a waiver only pertaining to UCSF. It's pertaining to the University of California generally.
I thought that's a matter of law.
I'm sorry?
Those are matters of law, you said, that he isn't going to participate in any future transactions involving UCSF.
Right. That's a separate rule. This one, the one.
All right, that's included in the motion.
Okay.
Okay.
That's not work.
Is there a second?
I'll second it.
Okay. All in favor?
Aye.
Aye.
Make sure that we're saying UC, because there's also Berkeley and other.
UCSF, University of California at
conflict is
San
with-
Francisco,
the conflict is
350
with-
Parnassus Avenue.
No, the Supervisor Sheehy, I want to understand, is it the University of California?
I have the conflict with UC.
Yes.
If you limit it to UCSF, I cannot look for opportunities at Berkeley, which I've been looking at opportunities at Berkeley as well. I don't. I mean, you're basically telling me I can only work for one. The conflict is with UC.
When I voted for it, I was with the assumption that it was the University of California, not limited to UCSF, because the contracts that we were concerned about were with the University of California.
Yeah, if we can have that clarifying.
So it would be with the University of California.
Amend?
We have to amend.
Amend?
I don't think we do. Thought my motion was the University of California.
You did say
You did
University
say,
of
you
California.
said, you
All
specified
right.
San Francisco,
All right.
so.
Yeah, so just procedurally, why don't we do just a quick motion to rescind the last matter and then redo the
Move
motion?
to rescind.
Second.
Aye.
Aye. Okay, so
Aye.
motion rescinded. So,
I'll make the motion again to grant the waiver with the conditions articulated by Mr. Ford to the applicant, Mr. Jeff Sheehy, to go to work for the University of California.
Second.
If I could just add, just briefly, work in the University of California, subsequently get a waiver from the requirements of 3.234A3, and make a finding of extreme hardship.
okay, so,
Motion's based upon a finding of extreme hardship and de minimis participation in 3 innocuous resolutions as far as potential conflict is concerned.
and the waiver is with respect to post-service employment contained in the code section 3.234A3. Okay. Is there a second?
Second.
All in favor? Aye. Okay, the motion passes unanimously. Thank you, Supervisor Sheehy, for your service, and good luck in the process.
Thank you for that letter of application. It's interesting.
Okay, so the next item is Agenda Item 6, the discussion and possible action on requests by the following candidates in the November 2018 election to appeal ineligibility for public financing under San Francisco Campaign and Governmental Conduct Code Section 1.142A. There are 4 respondents or 4 appellants, And from a process standpoint, I would like to take each of them individually. So we'll hear from staff and from the appellant, and then the commissioners can ask questions, and then we'll have public comment, and then we'll go through them in the order laid out here under agenda item number 6.
Thank you, Chair Chu. I'm just going to do a quick introduction. Pat Ford, obviously, will also be available for specific details. We have a memo under agenda item 6 and a series of attachments that have been provided as background on the issue that's before you in this agenda item regarding the eligibility of candidates to participate in the public financing system. The first thing I wanted to highlight also is that at the last commission meeting, Commissioner Kopp had asked some questions about how many candidates had qualified and how many candidates were participating. We thought it would be useful to just put together a snapshot of the current status of public financing for Board of Supervisor candidates in connection with the November election. So we've handed out to each of you, commission members, as well as placed on the public table, a copy that is public financing status of Board of Supervisor candidates, November 2018 election, as of July 19th, 2018, revised. If there's a member of the audience looking at a copy that does not have revised, we did correct some of the numbers during the meeting, so please look at the one that states revised. Just by way of reference, this cheat sheet identifies candidates who filed campaign statements with the Ethics Commission. So under the Political Reform Act, were considered candidates in our campaign finance world who had filed something with us, and they are listed by district. If a candidate filed a statement with us, they were identified here. There then is a column that identifies the date that the candidate filed with the Elections Department to appear on the ballot. As you recall from reading Pat Ford's memo, there is a deadline under the law for candidates to file nominating petitions to appear on the ballot, and that is also the deadline by which candidates must submit a statement of participation or non-participation in order to participate in the public financing program. Those dates that the candidates filed their nominating petitions with the Elections Department appears in column 2. The current ballot qualification status, as indicated on the Elections Department's website, is shown in column 3. Some candidates qualified for the ballot, other candidates did not. In one case, there was a candidate who withdrew from the ballot after qualifying. And then the 4th column, you'll see the date and time that the candidate filed their statement of participation or non-participation with the Ethics Commission. This is here just for reference to show district by district for those candidates who did file a statement with us. The date stamp that the system through which it is filed noted, it appears here. Some you'll see did not file. And then lastly, just a couple of points of information. The intention stated by the candidate, whether they opted to participate or desired to participate, or whether they declined to participate, that is also shown on this table, as well as of today, by the time this meeting started, the status of candidates who have in fact qualified to receive funds or who have not, for whom no determination of certification has been made yet. So again, this just gives you some overall perspective. And I'll come back to the summary on it in just a moment. But on the memo that you will have reviewed, you'll recall that the public financing program establishes a variety of provisions in the law for candidates in order for them to be eligible to participate in the program. 2 of the key questions that are identified on our chart. One, candidates are required to submit a statement of participation or non-participation by the end of the nominating period during which they are required to meet a deadline to submit nominating petitions to the Department of Elections. There's a separate process that a candidate can also submit qualifying statements within a specific time frame and by a certain deadline to actually ask to be certified as eligible, because they will have demonstrated having raised a certain number of contributions from a required number of contributors and so forth with the sufficient documentation. Those qualifying claims are also can be filed up to a certain deadline. Those 2 requirements are not necessarily sequential. The law does permit a candidate to submit either their statement of participation first or their qualifying statement first, but each of those documents and those filings must be done by the required deadlines that are established in the law. So the summary information for context, and then I'll perhaps turn it to Pat if there are any additional information that he wants to share, or perhaps if you have questions of either of us. In terms of an overview, there were 39 candidates for the November election who filed a campaign finance disclosure statement with the Ethics Commission indicating they were raising or spending money in a way that qualified them to file some disclosure statement with the Ethics Commission. Of those 39 candidates, 23, or 59%, so just over half of those candidates actually qualified for the ballot. Of those 20, of the 39 who filed to run for supervisor, a campaign statement, 25 of those 39 filed a statement of participation or non-participation with our office. And then of those 25 who filed a statement with our office, 76% of them filed their statements timely. So 76% filed their statements timely. 24% or 6 filed after the deadline. So again, this chart provides breakdown information that might be relevant to you. There might be other questions that you have of us, and I'll just pause here, noting that there are additional documents in the memorandum that we provided, comment from the various candidates who, when they were notified that they had not filed a statement timely, that they sought an opportunity to bring the issue before you and to have the issue considered.
Commissioner Rennie.
Can I ask Ms. Pelham, now the candidate has to file with the Board of Elections by a certain date of their intention to seek office, right?
That's correct.
And they can't raise funds for a campaign until such time as they file that?
No, they can raise funds prior to that time, and some do.
All right. Now, do you know, has the Board of Elections ever allowed a candidate to run for office who failed to file by the time set out in the charter?
I do not know that. Maybe the city attorney has any insight?
I don't want to necessarily speak for the Department of Elections, but after being in City Hall for roughly a decade now, I've never heard of such an extension for any elections-related papers.
Thank you.
Any other questions from commissioners for staff? Commissioner Lee.
If I could ask the question to the Assistant City Attorney, even though the Department of Elections has never allowed someone to run, was the District 4 extension unusual then?
The District 4 extension is sort of a standard approach in elections law. Then if an eligible incumbent chooses not to seek re-election, that there is a 5-day extension. So that is a well-recognized feature of election law. It just doesn't happen very often because most incumbents who are eligible to run do in fact run.
Okay. Director Pelham or Mr. Ford, can you clarify for us what communication or emails were sent and when to treasurers as well as candidates in the lead up to the initial June 12th filing deadline?
So for one, our website has a landing page for public financing that lays out what the various requirements are. So the requirement was stated there. So any candidate who would go on our website, click on public financing, would see that the statement was a requirement and it has information about how to file it and when it's due. As to communications directly to and I should also mention that the supplemental guide for candidates seeking public financing is also linked there, and that guide also has a lot greater detail and also explains the requirements. So aside from those materials that are just generally available, we did send out on June 4th an email to all Board of Supervisor candidates and their treasurers, basically stating that this deadline was approaching. At this point, the deadline was 8 days away. And it has a link to the code section that requires it. It has a link to our e-filing system. It has a link to the website that I just spoke about, and it has our email address if people have questions. So Johnny Hosey in our office sent that out, and he's confirmed that he sent it to the list of everyone who had declared as a candidate as of that day, as of June 4th. So any candidate who'd filed then should have gotten this email. And after that, then on the 13th, we sent an email to any candidate who had failed to file by the 12th, notifying them that they had failed to file. And I should narrow that we also notified candidates in districts 4 and 8 that the deadline had been extended. So I think I misspoke actually. So the notice on June 13th was solely about the extension. We did not notify candidates until the 26th. That's when we followed up with our communication about ineligibility. 13th was we were notifying the candidates in districts 4 and 8 that they had an additional additional 5 days to file.
Okay, so there was an email, so there was the landing page of the website along with the information contained in the voter guides, plus the reminder email that went to candidates and their treasurers on June 4th,
Correct.
as well as an email on June 13th due to the extension of the deadline for Districts 4 and District 8.
Correct, and that June 13th email does reference the deadline for the statement of participation.
I see. Okay, thank you. All right. Mr. Ford, did you have any other, did you want to comment at all on the specific of any of the cases?
I'd be glad to provide factual background insofar as that is helpful. I don't know if you maybe want to do that one by one as you call them. Globally on this issue, I think Director Pelham summed it up, gave a nice intro. I would just add that it is staff's standard practice to deny eligibility to public financing to any candidate that fails to file this form by the deadline. It's not our practice to accept them late. And also, there was an appeal that factually is quite similar to certain of these appeals that was in 2010, where 2 candidates did ask the commission to essentially accept late filings for the statement of participation, and the commission did deny both of those appeals.
Thank you.
Chair Chu, if I might, just one last note as well, but as you turn it over to the candidates and public for comment. When we looked at the summary information provided in the chart, one of the things you mentioned was the different deadlines. In 2 of the races, the extension was granted in the Department of Elections an additional number of days. And when we look at the filing statistics for candidates in those races by whether the deadline was June 12th or June 18th, 77% of the candidates who faced a June 12th deadline did file their statement of participation timely, and 75% filed timely for the deadline of June 18th. So in both cases, the vast bulk of candidates were able to submit their documents on time. I think that's just important context to have as a background point of information. And as the report indicates, we did give our thinking to this process, and feel that it is important to just point out that there are candidates who have abided by the applicable deadlines, and that we would hope that the program can be applied predictably and uniformly based on the requirements of the law, so that candidates who do apply are not subject to unequal treatment.
Thank you.
But
Commissioner Rennie.
if staff is, as it recommends, that these deadlines should be enforced and shouldn't be extended, how do you explain letting candidate Marr file late?
I would clarify and correct, actually, candidate Marr did not file late. The law does not establish, it establishes a deadline on the date. We have an electronic filing system, and as you might recall with the case of Ms. Alioto, candidates can file statements up until 11:59 p.m., and it is filed on that date. So Mr. Marr, who filed his statement at 5:40 that day, on June 12th, I believe, was not a late filing. It was received by midnight. Thank you for clarifying questions.
Thank you. Any other questions from commissioners? No. This time, then, I'd like to invite Sonia Traus.
Chair Chu, Commissioners, I am not Sonia Traus, but I am her attorney here on her behalf. Pleasure to be here. And we are asking you to actually rule in her favor on her appeal today. We submitted a lot of documentation in support of her request, including a letter that laid out all of our sort of main arguments. And I'm happy to sort of go through the main points if you'd like. Otherwise, we do have a few extra points that we'd like to make sort of in response to some of the things that staff has said, but also just more generally that wasn't covered in the letter. So,
Who do you represent?
Sonia Traus, District 6 candidate. Oh, yeah, I'm sorry. Jesse Maynardi, I'm her attorney. Thank you. So, general arguments first and then the
Sure,
points?
unless commissioners have specific questions at the top.
What reason should we not strictly enforce the statute? There's nothing confusing about it. I mean, the newspaper, I remember your client or so one of the clients saying, well, the staff shouldn't be super technical. When it says file something by date, what's technical about it?
Well, I think what we would say in response to that, Commissioner Rennie, is that it would be not only sort of unfair in light of the entire set of circumstances here, but it also would be elevating form over substance. And the reason we would say that is because Ms. Traus, she submitted her qualifying request, so 100 contributions on February 9th, back on February 9th. That was the first of 6 that she had submitted. And there was constant back and forth with staff at that point, from the 6th all the way up to June 13th. And this was a mistake. I mean, there's no question this was a mistake, right? So if you look at the underlying purpose of the form, what is the underlying purpose? To provide notice to whom? To staff and to the public, right? That's what.
And to other potential candidates.
And to other potential candidates, correct. And so, as Mr. Ford points out, those are the general underlying purposes. Well, I mean, those purposes were met, certainly with respect to staff, because staff spent significant amounts of time dealing with these qualifying requests over the period of at least 4 months. And for the public, well, or other candidates, I mean, how do they find out about this? Well, they go to the website. And on the website, what they would see is over the course of 4 or 5 months, request after request after request after request. So, I mean, I think for purposes of the intent of that rule, which, frankly, with the advent of electronic filing, I'm not sure, how important it is, but let's assume it is. I mean, that intent to participate was loud and clear, both with respect to staff as well as with the public or any potential, opponent. So I think that's general gist of our argument. I mean, it would certainly further the purposes, obviously, of the public financing. This is a race with 3 very strong candidates who have very different points of view on a lot of public policy questions, and this will be certainly make things much more difficult for Ms. Traus in terms of getting her position out. And this is very different than what was brought up by staff. I appreciate what he brought up in terms of 2010. But in 2010, you had 2 candidates who on the last day, in the time of no electronic filing, bringing these 2, the 142, the notice of intent, as well as the qualifying request. This is very different. Here, this has been going on for months, and submissions have been made, they've been rejected, back and forth. So it's not a case of someone who's sort of late to the game. It's someone who's been in the game, who's been participating in the game since February 9th. So anyway, that's answered.
I have a follow-up
Yes.
question, and then I think Commissioner Kopp and Commissioner Lee. So 2 things. One, the candidate and the treasurer, I believe, received an email reminder to file. That email was sent out on June 4th. So notwithstanding the back and forth with the submissions, but there was a reminder specifically to say, please, don't forget to file by June 12th. And so, that's one. And then second, on those the request for qualification, there is a section in here where the candidates will sign and attest under penalty of perjury that they actually have in fact filed the statement of participation already, and those were submitted 6 times. And so, what's your response to the email reminder on June 4th?
Sure, yeah, no, that's a good point. And I mean, I think in terms of the answer to that is that the short answer is that Ms. Trouse never got the email, and not because of staff, but she never got the email. And to sort of give you the context as to how this works and why she didn't get the email, and why this whole thing was really, and Shonda Dean is, a good person, and Kim Lutz, those folks are great, but this was their mistake. They were engaged by Ms. Trouse to be the professional treasurer. And when you do that, you are paying somebody a lot of money to help with this process. And she was relying on them to know what they were doing and know all of the requirements. Now, they did a couple of things in retrospect. You look at it and you say, why would you submit only $10,000, right? Why would you submit only $10,000 and 100 donors? Because you know you're going to get denied, right? At least one. So this is indicative of sort of the general mistake, the general sort of lack of experience, even though they were being paid by Ms. Trouse to do this. Now, when they signed up, they submitted, as required, 2 email addresses. One was Shonda Dean or Shonda at shondadean.com as the treasurer, and the other was Sonia2018 at shondadean.com. So that June 4th email went to those 2 email addresses. Now, it's unclear, we've been asking them as to whether they saw it, but in any case, that email was never forwarded to Sonia Trouse at all, either on June 4th, immediately after June 4th, June 5th, whatever has it, which, by the way, was a busy time because it was right the day before the mayoral election. So I guess my answer to that is just she never got the second email, and it certainly is a requirement. It's certainly in the materials, and it was certainly a mistake, but it was a mistake by a professional treasurer on whom she reasonably relied and who put herself forward as being an expert in this area, and who, submitted 6 qualifying requests over the course of 4 months. So, I'm sorry.
Yeah, I mean, with regard to the email, it's like the staff and the commission can only send notices to the email addresses that are provided to it, and so what happens after it's sent out is beyond the control of the staff, and that I'm sympathetic, and it's a difficult situation, but how it works once the email goes out, it's not up to the commission to rectify.
No, and I am certainly not saying that staff did anything wrong. I mean, they sent to the email that was given to them. I'm just saying, in looking at the general context, I don't think that my client necessarily did anything wrong either, because she relied on somebody she was paying a lot of money to provide her advice, and for all that she knew, was engaging. I mean, the intent to participate in public financing. I mean, she participated in public financing over the course of 5 months. So it would just seem, and if you were to look at the materials, if you were to look to attachment 7, and you'll see the form. It's a 1-page form that is a click. And the way you submit it is the treasurer goes into their net file and they click it. And that's it. And it would just seem a shame that after all of this work for over the course of 4 months, where qualifying request was submitted after qualifying request, and then was come back, and then there would be denials and then back and forth, that because of that single click, even though everybody knew, and anybody who had any interest to know, that she was participating, that she would be denied the opportunity. And she's not asking for funds yet, because she hasn't submitted enough to qualify, but she will qualify, because as of the last set of donations that were submitted, there were 7. She was missing 7 out of 100. And she has hundreds more that she could submit.
Questions from Commissioner Kopp and then Commissioner Lee?
Isn't it a fact that your client has been running for the Board of Supervisors since 2016?
2017, I believe.
2016, I said. That is in one of these documents. She filed her declaration in July of 2017. All right. Even accepting July of 2017, that's 11 months from the deadline, and she is not new to civic endeavors. What is the reason that after officially in July 2017 and from a de facto standpoint from 2016, that she wouldn't be held to the legal requirement of June 12th or June 18th?
June 12th.
Well, for a number of reasons. First is that she could not actually participate in public financing until February 6, 2018. So prior to that, there's no participation that is permitted. That's the first time you can actually submit a qualifying request.
Well, how about her knowledge? Didn't she have knowledge before February 6th of 2018 of public financing?
Yeah, definitely. And that
And
day
did
one,
she have knowledge of the requirements?
I think she had a general understanding of the requirements.
And isn't this Ms. Dean, whether you consider her a professional, and of course she abrogates knowledge of San Francisco's laws, isn't she an agent of Ms. Strauss?
She is definitely an agent of
All right,
Strauss.
thank you.
Commissioner Lee?
Thank you, Madam Chair. I echo everything that's been said. You do agree that the staff had done all the due diligence to keep your client informed. Everything is out there. So it's very unfortunate that it seems like the person Ms. Strauss hired as her campaign treasurer happened to miss a deadline, but that's between her and the person she hired, right?
Well, no, I don't think so. And I would disagree because, and again, I don't ascribe any sort of ill intent on anybody, let's say. But this was a lot of participation in this program over the course of 4 months. I mean, the back and forth, which you can see. And I would just urge you to look, compare the form, that one form in Attachment 7, with all of the documents that were submitted over the course of those 4 months. And there was an assumption, correct, that everything was in place because nobody said the staff, which to their credit, affirmatively pointed out that Mrs. Strauss had a late filing fee that she had to pay, right? It turns out she didn't have that late filing fee, but they affirmatively pointed that out. I mean, that's the level of the back and forth. So there was an assumption. I mean, there was no doubt that there was a mistake, but there was an assumption that things were in order, so that the real issue was whether somebody who lived in a commercially zoned area or not actually lived there. I mean, that's what we were talking about in terms of the back and forth. So it just seems to me, if you look at the general context and you look at the purposes of this rule, which are signifying your intent, this is not, Ms. Strauss is not like the people in 2010 or even other folks here. It's not like she's late to the game and all of a sudden she's like, here, I want to be here. She's been here and she's taken up a lot of staff time and she's spent a lot of time on her end. And she will, if you guys let her, she will qualify. There is no doubt she has all of the donors. And I will say one thing, I do want to correct one thing that was said, is that the law in terms of Gordon Marr and in terms of Gordon Marr's participation, the law is very clear in the Municipal Elections Code that it actually applies, the deadline is at the end of business hours as posted. That's what the law says, Municipal Election Code 205. It said, must file nomination papers no later than the 147th day before the election during normal office hours as posted. And both for the Department of Elections and the San Francisco Ethics Commission, the posted office hours are, I don't know if it's 9 or 8 till 5 o'clock. So these are, now I'm not saying take it away from Gordon Marr, and I'm not saying take it away from anybody else who was subsequent to 5 o'clock. I'm just saying that if you are going to apply the law so strictly, you're going to be led to sort of extreme and unreasonable results. And so I just encourage you guys to look at this in context and look at what has happened and why Ms. Strauss thinks that she was participating, and everybody knew it. So a click in a computer screen wasn't going to make a difference.
I just want to
Commissioner Lee.
reinforce that deadlines are set for a reason, and you know the deadline was missed, and you admit that an error was made. It was made by the treasurer.
But if I could just say that deadlines are set for a reason, and what is the concern here? The concern is that you're going to open up the floodgates to everybody, right? But this is not any other situation where somebody is in at the last minute. This is a situation where somebody is actively participating. And I submit to you that it is very unlikely that you're going to have a situation where somebody who is actively participating over and over the course of 4 or 6 months is going to be, that you're going to be getting a lot of these. You may get a lot of the other time, which is people who are showing up at the last minute who say, hey, I mean, that's their thing. This is a very, very unique situation. And you folks have the ability to do this. You did it for Angela Alioto. There was a confusion there. There was a confusion over the deadline, yet there was a firm deadline. There was a firm deadline in both the regulation and in the law. And she, by the way, was missing over 280 donors, or about 280 donors. And you said, that's okay because there was confusion and there was mistakes. In this case, we're talking about a click and we're talking about 7 donors and participation over the course of 4 months. It would just seem, if you look at the totality of the circumstances, it would seem fundamentally just the wrong thing to do to say, we're strictly going to go by this deadline, when the deadline and the purpose of the rule, the purpose of the form was met over and over again.
Just one last question, Mr. Minardi. In the candidate declaration on the request for qualification, it states that, I have filed the statement of participation or non-participation on which I indicated my intent to participate in the public financing program. Now, these are electronic forms. I don't know if your client looked at them beforehand, but, one of the obligations of the candidates, and certainly I would hope anyone running for office would read all the documents before they sign their name to them. But, she certified under penalty of perjury not once but 6 times that she filed this statement. And so, what do you make of that? How do you respond to that?
Yeah, so she made a mistake. She made a mistake, which was that she had thought that it was filed. Again, it's something that's done she does not do it, by the way, when you have the software. She does not do it. The treasurer does it. It's through NetFile, which is the software that everybody uses. And so it's a click down.
Well,
yeah.
When you say that she doesn't do it, this is supposedly signed under penalty of perjury by the candidate,
right,
not by the treasurer.
Yep.
Right? So she represented, as you say, 6 times that I have filed a statement of participation, in which I indicated my intent to participate, and she hadn't filed it.
No, she hadn't. She made a mistake. No.
Under oath, she filed that.
Well, and let me be clear, she did not deliberately lie. She did not deliberately say, hey, or she didn't lie. I mean, she wasn't deliberately saying, hey, I filed this when I know I didn't file it. She obviously made a mistake. She obviously made a mistake. There's no dispute here. The question is, if you look at all of this and you think about the underlying purpose of this, what would be served? What would be served by denying her at this point?
Thank you.
Anyway, let's see.
Any other questions for Mr. Minardi?
Okay. Okay. I have, if you want the law too on the municipal elections code, I have that too for you. And the filings are, the dates are there. So, thank you. Thank you very much.
Public comment?
While people are coming up, can I ask a quick question of the staff? One of the things, because I'm new here, I don't fully understand, why would somebody come in and file the detailed qualifying contribution reports? Why do we accept those before we know whether or not somebody is signing up to participate? Why do they wait? Is it just because the code says they have to file that they will participate on the very last day that they sign up to be on the ballot?
Essentially, there are deadlines in the code for each of those forms. There's a deadline for the statement of participation. There's a deadline for the qualifying request. The deadline for the statement of participation is earlier than the deadline for the qualifying request, but there's nothing in the code that says, and you must file them sequentially. So as long as you comply with both deadlines, you could file them out of order, and staff has accepted that in the past. If candidates file a qualifying request and then they file the statement of participation, staff has accepted it because technically the deadline doesn't say they have to be filed in order. You just have to meet the deadlines for each, which, by the way, it's the 147th day before the election for the statement of participation and the 70th day before the election for the qualifying request.
Okay, I'm just concerned that you might be spending a lot of time reviewing a bunch of stuff for somebody that never signs up for the program. So when we get to the next agenda item and talk about how to maybe make improvements based on our experience, we want to just think about maybe they should file when they're bringing you all that workload.
I think that comment would be very well received.
Yeah, okay.
But isn't it true that this qualifying request contemplates that there's already been a filing? Why is it that the commission accepts a qualifying request where the candidate says, I filed it, but I haven't filed it?
Right, because the form in contemplating that would apply a stricter standard than the code. The form would seem to apply a sequential requirement, but the code does not. So giving the candidate the benefit of the doubt of the more lenient standard in the code, we would accept them out of order. But you're correct. If we applied the form, what it says on the form, and the declarations under penalty of perjury, if we applied that very stringently, we would immediately reject it. But the practice has been to, as long as the candidate was still before the deadline for the statement of participation, allow them to turn it in.
But wouldn't it be wise on the part of the staff when they get a qualifying request and there is no filing of a intent to participate, that they notify the candidate, hey, you've got to file that, period?
If I might add, respond, Commissioner Rennie, there are, you'll recall, a number of provisions of the law that the staff also has to check to confirm eligibility requirements, such as, is there an outstanding fine, a penalty that somebody hasn't paid? So there are a number of things that the staff has to check in order to determine eligibility. Arguably, those could be things that we would say we're going to review before accepting a qualification statement as well. I think historically the staff has, again, given the committees a benefit of the doubt with the way the law reads to be able to submit what they have to submit. We'll take a look at it and review what, if any, filings exist or don't exist that might affect their eligibility, and then let them know based on that review. It could be an alternative to simply stop it at the front end, at the front counter, but we think that it's been as much of a fair process as possible to allow candidates to submit their documents for the review that we have to conduct in any event.
You wouldn't have this kind of a situation where they argue, I did all this work and raised this money, and then you cut me off. Okay.
Public comment. Thank you.
Hello, Commissioners. My name is Eddie Siegel. I'm a volunteer for the Sonia Traus campaign. I urge you to support her acceptance of public granting funds. Ms. Traus submitted a form that, as far as I'm aware's only purpose is to express interest in qualifying for the Matching Funds campaign. Ms. Traus is an activist, a former teacher, She is exactly the type of person that the Matching Fund campaign is slated to help and to fund. We want to make San Francisco a democracy that supports grassroots campaigns. It supports people that do not need big relationships with big donors or have the advantages of well-connected incumbency. And it seems to me that, as the lawyer spoke before this, that there has been an active line of communication with the Department of Elections. At no point did any of her competitors in the race, did the Department of Elections not know that Sonia was intending to apply for the matching fund grants? If this group here wants to support teachers, wants to support activists, there are other teachers and other activists that are also applying for this appeal that wants to make San Francisco a democracy for everybody. It seems to me that the 25% failure rate spoken earlier is actually pretty darn high. And if the lawyer was correct in saying that there are additional people filing after 5 p.m. that would increase that 25% even further, that this process is not a perfect one for our city. And this should be a great time to revise this and accept the fact that people that are intending to participate in this matching funds program deserve it. Commissioners, if you deny this appeal here, you'll be saying to the city that what we trust here is specifically the technicalities of the law and not someone that wants to be an activist for this city, wants to run for matching funds, has shown consistently that she wants these matching funds, and that a single check of the box is really your determination on whether or not someone deserves this. I believe that's all I have to say. Thank you for your time, commissioners.
Thank you.
Good afternoon, Commissioner. My name is Pius Lee. I'm a supporter of, I was a former Port and Police Commissioner. I'm a supporter of Sonja for Supervisor in District 6, and I was disappointed that Sonja was told she cannot participate in a public finance program. Even she made a mistake, but it was an honest and unintentional mistake. Therefore, I ask you to consider to give her another chance so that she can deliver her message to the voter in District 6. As you may know, the goal of public finance program is to help as many candidates as possible to get their message out in their district. So therefore, thank you very much for considering my recommendation to you. Thank you.
Thank you.
Hello, Commissioners. My name is Ben Libby. I work for Sonia's campaign. So since the beginning of the campaign, the intention to apply for matching funds has always been pretty clear. We always planned on doing it. We started submitting qualifying requests as soon as possible. It was delayed because we were told that we could not submit qualifying requests until Sonia had cleared fines that were assessed to her by the Ethics Commission. The fines were assessed incorrectly. I believe it was about $14,000 worth of fines for a committee that the Ethics Commission did not have jurisdiction to issue fines over. We've gone back and forth repeatedly. The standards for public financing have been extremely unclear. In documentation provided by the Ethics Commission to candidates, the wording is extremely vague about how many donors you need to submit and how much money. It clearly states you need 100 donors, $10,000. But it's unclear whether it means exactly 100 donors donating exactly $10,000, which is the understanding of other people who've gone through the process in the past who advised us, or whether it's at least 100 donors, at least $10,000. When I asked staff in the department whether which was true, they didn't know. I went to the department 5 separate times. Only one of those times was someone who actually dealt with the public financing program available to speak with me. I went at different times on different days. The guidelines are extremely vague. I got different answers about different things from different staff members. And frankly, we're running a grassroots campaign. And our campaign is only possible. We can only run a campaign the way we are because public financing is available to candidates. Frankly, we are running against some extremely well-funded opponents. And I think, our sort of campaign is exactly what the program is intended for. And it would be a real shame if we were unable to participate because of a single oversight. Also, on the subject of the accountants, it may seem confusing as to how, there was the lack of communication, but because only one person can file electronically on behalf of the campaign at a time, no one on our staff in our campaign was able to actually, access the e-filing system, so everything we did had to go through the accountants. The accountants are based in Sacramento, so, talking to them face-to-face is pretty much impossible. Everything had to be done over the phone. In conclusion, we have more than enough donors to qualify, far more than we need, and I hope that you can grant this appeal so that we can, fulfill the purpose of the public financing program. Thank you.
Thank you.
Thank you, Commissioners. My name is Adam Goldstein. I'm a longtime supporter and an early donor to Sonia's campaign. And I just want to be clear about the stakes here in this election. This is a highly competitive race that has the potential, just as our recent mayoral election, to be decided by only a handful of votes. And in particular, the winner of this election has a high likelihood of being the tie-breaking vote on many issues before the Board of Supervisors. The impact on our city's democracy is very high in this election, and I think that suggests that all of us should be aware of the consequences of ruling on technicalities in light of the public interest. There's no denying the facts of the case. No one believes that Sonia had any malicious intent here. The question is whether this mistake should disqualify an otherwise qualified candidate from the public financing that the city of San Francisco's own voters voted should be in place for candidates precisely like Sonia. And discretion is built into the system. It is not the case that these issues have uniformly resulted in candidates' appeals being rejected. Angela Alioto's was accepted. Another supervisor filed 40 minutes after the deadline stated in the rules, and the staff accepted that and used their discretion for it. The question before the Commission is whether discretion is justified in this case. We can't simply rely on the rules being the rules, because that is not the way that we've applied these decisions in the past. But the stakes here are even higher because San Francisco in particular is a laboratory for democracy. The issues that are being discussed in this campaign resonate in cities across the country and in our national politics. And if two of the other candidates are able to make their case to the voters, but Sonia, who brings an outside perspective, is not able to bring her case to the voters, then the voters are going to have a poorer understanding of the real choice that they face. Now, if the voters decide that the clerical error made by Sonia's accountant should disqualify Sonia for public office, then they will vote against her and she will not take office. There is accountability built into the system with the voters of San Francisco. But if the voters in San Francisco, in Sonia's district, are able to learn of her campaign and they believe that the ideas and the policies that she brings are important enough to elect her to office despite this clerical error, then that will be better for the democracy of San Francisco and better for our country as a whole to have people bringing those ideas to office. So the most important question the Commission faces is, how can we ensure that voters get an adequate understanding of the choices in this election? And there's no other remedy that is available to the Commission today to ensure that the citizens of Sonia's district get that information. There's no other remedy available that educates the citizens of that district than to grant an exception in this case, as exceptions have been granted in other cases. The rules are not meant to restrict democracy. The rules are meant to promote it. And when the principles outweigh the rules, then we have to make an exception.
Thank you.
Yeah, Madam Chairwoman, I thought this issue of somebody filing 40 minutes late had been settled. Because if it's been settled, it'll have no effect on me to make an argument based upon a alleged violation of laws and an analogy. Did that gentleman file timely, or was the filing late? And if it was late, how much late?
Judge Kopp, Commissioner Kopp, as I mentioned before, the question was directed at the filing by Gordon Marr. He filed a statement of participation on June 18th, which was the deadline date. He filed it at 5:43 p.m., and there is not a law that applies to these filings that limits the receipt of these filings to 5 o'clock p.m.
Thank you.
Thank you.
Hello, my name is Vadim Grabois. I am a supporter of Sonia Traus, and I donated to her campaign. I was hoping that this donation would be matched with public funds, and I was very shocked to find out that because of a small error that the campaign made, that it would not be. So yes, I agree that a mistake was made, but it looks to me that the spirit of the law was followed and that she intended to accept public funds. And I feel like it would be a tragedy for the voters of District 6 if a small paperwork error prevented them from getting, the full choice of candidates that they could get in this upcoming election. Sonia has a very unique voice, and I think it's very important for the people of San Francisco to hear it. She's an outsider candidate. She is not an insider. She does not have much political experience. So I hope that you can grant this appeal. Thank you.
Thank you.
Hello, my name is Tom Hirschfeld, and I'm here with a brief statement. So if you deny Sonia public financing, you are punishing the voters and the democratic process of San Francisco for a clerical error of her treasurer. You are supposed to be stewards of democracy. The voters of San Francisco fund the public financing that Sonia is seeking, and the voters of San Francisco would not seek to exclude her and the other 4 candidates that seek public financing and failed to follow the process. Thank you.
Thank you.
Good afternoon. My name is Stephen Bust. Sonia Traus got me into political activism. I've seen her organization grow from a few angry renters in the Bay Area to a worldwide movement of people fighting for a common goal. When I heard she was running, I was super excited. I donated immediately. I think I'm like number 8 on the list in the packet. I was so excited for her campaign. I hosted a fundraiser at my house or my apartment in October of last year, and I was very clear to everyone in attendance that we would be seeking public financing and that every donation given would be matched by the city. This pattern was repeated at every single fundraising event that I attended. Sonia would always say she intended to get public financing and that it was a great part of San Francisco. I even went on 2 months of unpaid leave to volunteer for Sonia's campaign earlier this year. And in my time at the office, it was always discussed that, yes, we were going to get public financing. I even tried to assist in the first document that in collecting the donors that were, collecting the list of donors and handing that to the accountant. They ended up not using it, but I tried. It has never been unclear that we were seeking public financing, and as the attorney mentioned, by filing, it lists us on the website as engaging in the process. I really hope that the commission doesn't, I hope that the commission does grant Sonia's appeal and the appeal of the other contenders, because it would be a shame to deny her the right to seek this over a simple mistake. Look, I'm a software engineer, and if I had built this net filing software, it would never have accepted submissions unless you have met the requirements. Like, if we're going to enforce this checkbox, then it needs to actually be enforced as part of the process. Staff members should not be reviewing submissions if this form has not been submitted. The website should not accept submissions if the form has not been submitted. There is failure at many levels, including on Sonia's campaign and in the software. And I urge you to please don't punish her for mistakes in the process and the software and from her accountant. Thank you.
Thank you.
Hello. My name is Milo Traus, and I also think that you should grant this appeal for a number of reasons. So to start, and kind of picking up where the previous speaker left off, it's clear that our system has some issues. It's not the best. It's not the clearest. The intent is there that we want to encourage more participation from more kinds of candidates who aren't the best resourced. And I think Commissioner, I don't have the best eyes, Rennie pointed out, got to the essence of this well, that it doesn't make sense to accept documentation based on the filing of a separate form without having first gotten that form. Just doesn't, it doesn't make sense. And so the spirit here is to get more people to participate. And here we have a candidate who's a grassroots activist who 2 years ago was a math teacher who hired professionals to help her navigate this process, which in itself is already a mistake because we don't want to design some sort of ethics compliance where all the candidates need to have enough money to bring in professional lawyers and accountants to help them go through. So moving forward, I think we could simplify it even more. And then one of these professionals happened to slip up. So this commission has the power and I think the vision, the wisdom to see past these shortcomings and how we design the letters of this law, the structures of these forms to be able to grant this appeal. Another commissioner, Commissioner Lee, mentioned that this deadline was set for a reason. It's set for a reason to move the process along, right? It's not set for a reason to disqualify and restrict access to democracy. And so if you miss the deadline, issue her a fine, but don't torpedo the entire campaign of someone who's worked so hard and who so clearly had the intent to follow the rules. And so finally, I would like to point out and challenge the word of staff here that it says pretty clearly on the law that statements must be filed by the candidate with the Ethics Commission no later than the deadline for filing nomination papers. And the city's charter says candidates for mayor and the Board of Supervisors must file nomination papers no later than the 147th day before a municipal election during normal office hours as posted. 5 p.m. office hours prominently posted. So that's the letter of the law. We've made the exception before, and I think that's fine. So I think we should make it again. Thank you.
Thank you.
I just want to begin by thanking the commissioners for your service in the city of San Francisco. My name is Amir Abner. I'm a former resident of District 6. I am not a volunteer. I am not a part of this campaign, but I am a supporter of Sonia Traus. First learned of Sonia a few months ago, and I moved here being a resident of District 6 as a graduate student here at the University of San Francisco. And when I learned about some of the things that you were doing in the community, and it's really being a grassroots organization trying to stabilize the community in San Francisco and not being displaced. When I heard about the finance perspective of this campaign and her not participating in the budget and the oversight, I just want to say that Sonia should be given this chance to run a fair campaign against these other candidates who are plugged into the system here in San Francisco, and this campaign just should be given a fair chance over just a small oversight. Thank you for your time.
Thank you.
Hi, thank you so much for hearing this, and I appreciate so much all the people that have come out today. It's really touching and an honor. Commissioner Rennie, I want to talk a little bit about how this works exactly, because some of your comments, I think, are good questions, and it sounds like what you're envisioning is what happens when you hire an accountant to do your taxes, where at the end, they usually give you actually the piece of paper and you look at it and like hand, sign. That is not how this works. In fact, so when you hire an accountant, they have to file electronically. They do everything electronically. There's only one sign-in. That's something my staffer mentioned before and I think is actually really important. I can't file anything. Once I hire an accountant, I am shut out from the system. So there's one sign-in, they file things, and then they send me a PDF after it's filed, or at the time it's filed. It's like a simultaneous automatic email. And then I look at that PDF. When in your packets, you can see the forms that are filed, my name is printed. So I definitely understand where you're coming from, and yes, when I have a piece of paper in front of me, any reasonable person, when you're looking at it and actually doing your John Hancock, I think there's a lot. I think you're imagining that I looked at that and I was just like, well, I don't care, or I wasn't thinking about it. But because I had hired these accountants and I had delegated many, many steps, there's quite a lot of work that they do. When they forward me a form that says, this is the thing that we filed, and it says on there basically that they filed the previous forms, I believed it because that was their job. That's what they told me they were going to be doing. Fairness, I think, is a big concern here, and it's come up a lot. And I think that fairness is an important consideration. The purpose of the public financing program is, one of them is to enable candidates to spend more time talking to voters, more time working on issues, building and strengthening coalitions, making sure the district knows me and I know the district. And in the interest of doing that, I hired people to take care of the accounting for me, like many candidates do. It's very common. I think probably most people are not doing their own accounting. And so that's where I think fairness comes in, which is that I did the things that most candidates are doing the same way that they are, but my accountant, didn't do their part. So I don't think that the interests of fairness would necessarily be served by really, as someone else said, dramatically torpedoing this campaign because my accountants made an error. Actually, a fine does kind of make more sense if you want to enforce a law or a rule. I am not the insider candidate. I am not the big money candidate. I'm not even the favorite in this race, although I think I'm the favorite, and I think I have a really, really strong chance, obviously. If I can't participate in public financing, I will have to spend a dramatically more time fundraising and much less time in the community. And I think that would be a shame, and I think that's not that would be the opposite of the point of the public financing system. Thank you so much.
Well, I have
Thank you.
a question.
Commissioner Kopp.
Yeah, you didn't provide me your name. Who
I'm
are
sorry.
you?
My name is Sonia Traus. I'm the candidate.
Oh, you're the candidate?
Yes.
All right.
Yes. Thanks.
Thank you.
Good afternoon, members of the Commission. My name is Rabbi Dr. Catherine Hansman Rothschild, and first of all, I want to thank you for your service to the county and city of San Francisco. I am here to plead and urge you to vote in favor of Sonia Traus for a simple fact that, one, she recently had a child, and also, second thing is that not granting Sonia this funding would greatly impact the race, because then it would prevent her from having a fair footing with the other candidates. Yet we all make mistakes. We are humans, and I plead and I urge and I beg you to vote in favor of Sonia Traus, and And I want to thank you very much again for your time and for listening to us. Thank you.
Thank you.
Hello, my name is Annika Steg, and I am part of Sonia's campaign team. I only recently joined her campaign, to be clear. Before I joined Sonia's campaign as just a private citizen of San Francisco, I was curious about which candidates for supervisor were participating in public funding, because I think it says a lot about their candidacy. So I went on the website that is public to everyone to see who had submitted anything for public funding, and I saw that she had filed multiple qualifying requests, and clearly that she was participating in the program, and that seemed good enough for me as a private citizen. I sincerely thought, oh, this is great. She wants to receive public funding. She, way in advance of the deadline for submissions, is submitting multiple filings. She seemed likely to qualify. Now, as part of her campaign, I know that she is incredibly likely to qualify. The campaign certainly has enough funding and the right kind of funding to qualify. It is just a matter of communicating the right information to ethics staff. I do know that the public funds process in San Francisco for candidates is confusing and not easily understood. It is not completely understood by many candidates or even treasurers when they take it on for the first time. I know it may seem odd, as Sonia said, that a treasurer filed on behalf of Sonia and signed for her, but as she said, it's my understanding that treasurers almost always file on NetFile on behalf of their candidates, that this is completely normal. I'm sure that all mayoral candidates who qualified for public funding in this past election had their treasurers file on behalf of them in this way. I believe that the public financing program in San Francisco is a vital part of our elections process. I think it's really fantastic that San Francisco has this. And I believe that it is a program that is constantly improving. So I really encourage you to exercise your discretion and rule in favor of Sonia. Thank you.
Thank you.
Hi, my name is Mark Press. I work on the Sonia Strauss campaign, but before I worked on the campaign, I, as a resident of District 6, was very excited to learn that Sonia was running for office and hosted a house party myself and was very eager to engage everyone in my network to help with her campaign. And I think the technicalities have been covered thoroughly, but I think it's just important that we acknowledge the point of public financing is to get the voices of underfunded candidates, candidates that aren't favored, to be able to spread their message. And I think that this commission needs to acknowledge that importance and take that into account when they're making the decision. Thank you.
Thank you.
Good afternoon again. Charlie Marsteller for the record. I think the public that are present today, I thought I would speak on a point on the system and how it works. This body is a quasi-judicial body, which means it's like a court of law and subject to appeal in a court of law. So you want to know that this body, whatever decision is made, generally has to follow the law. Now, that doesn't mean that the law is perfect. As you know, it never is. And it doesn't mean that the process has all the bugs ironed out. I don't think there's a process that's ever totally got all the bugs out of the system. And I'm optimistic that the system has been basically working fairly well because obviously it's garnered a lot of attention. And the list of people applying or looking at applying was quite high, which is a great sign. But I do want to make sure that the public understands that the opinion of this body is not an opinion. It is very much like a judge making a decision on the law. So their hands are tied to a large extent they can't bend rules without obviously someone else coming forward and suing the city or them, or basically violating their oath. So you want to keep that in mind, whatever decision comes out today. And I did think it was excellent to see such a great turnout and hear such eloquent and reasoned opinions by the public. It shows that the system is evolving in the right direction.
Thank you. Okay. So from a process standpoint, we had, we can now call Trevor McNeil, and then we'll vote at the, would do you want to vote? So from a process standpoint, I was suggesting that we vote on all four appellants at the very end, if you wanted to hear all the cases.
I object to that. Every appeal has different effects. And more than object, it would be improper.
Commissioner Kopp, that I guess we ought to deal with each case separately, and our reasoning may apply to all of them, but each candidate has a right to our best judgment of what is the right way to go.
Commissioner Lee, are you okay? Commissioner Lee, would that be okay? And Commissioner Ambrose? Yeah.
But at the end of the entire.
Okay. No, we can vote now. Is there a motion?
Well, I will make a motion if that's proper procedurally. At this point, Mr. Shen, who nods his head affirmatively. I'm going to make a motion to deny the appeal. I referred to the fact that the appellant has been a candidate for approximately a year, maybe longer. I can't locate the reference to campaign since 2016, but as a matter of public record, since July of 2017. She chose to act through an accountant. The accountant is her agent, and the accountant incidentally holds a state license to practice public accounting. The commission should be saying, pay attention to the law. The testimony declares that the appellant is an activist, and the file shows, for example, she has had transactions with the commission staff. In March of this year, there was a staff letter sent her entitled Determination of Ineligibility to Receive Public Funds under the San Francisco Campaign Governmental Conduct Code, based on February 27, 2018 qualifying request. And what that referred to was the fact that the appellant served as treasurer for two committees, the SF Bay Area Renters Political Action Committee, and Yes, in My Backyard Political Action Committee, which were assessed late fees under Code Section 1.10D in connection with late campaign statement filings. As of today, our records indicate no payment has been received for these fees. This letter is provided as a public financing program courtesy notice to inform you that this late fee remains outstanding. within the meaning of Code Section 1.140A3. And then staff conveyed another communication, apparently an email, to the accountant, Shonda Dean, saying, yes, in order to proceed with qualifying for public financing, the committee will need, meaning the committee of the appellant's campaign, to refile its qualifying request. However, you should be able to use the entities that you've already entered into NetFile when making such a submission. That was sent in answer to a specific question from Shonda Dean, who asked, does that mean we need to start over as a new submission? The appellant is no stranger to the electoral process in San Francisco, certainly in the last 2 years, as shown by this record or more. And intent is not an issue. I've heard testimony about no intent. As I stated, this commission's responsibility is to say, in this and all instances, pay attention to the law. The language of the commission staff is not vague or extremely vague, as a witness testified. And the evidence is clear. The evidence is convincing to this commissioner. The appellant has not obeyed or followed the law. She may have a cause of action against Ms. Sandra Dean for negligence or malpractice, but not any recognizable ground for the granting of an appeal.
So there's a motion to deny the appellant's appeal to extend the deadline. Is there a second?
Second.
Second.
I think this is really a difficult matter. If you look at the spirit of why we have public financing, and I agree, we want to make sure that there's a broader base of candidates who normally would not have the type of resources to serve the city. But at the same time, that's the issue of fairness and abidance to the requirements under public financing. And the question that I have is, there's a reason why there are deadlines to be met, and there is a reason why reports have to be submitted by a certain time, and is to be fair to all the candidates. If my accountant misses a deadline to file my income tax, IRS is not going to come after my accountant. IRS is going to come after me. I would have to pay for missing the deadline. And it's very unfortunate that in this case, someone the candidate has trusted to do all the proper filing for her missed the deadline. But I'm really concerned that if we were to go down this road that, you know, deadlines are set, and if someone comes in and there's another appeal, then we grant it, then those deadlines don't mean anything to other candidates who really abide by the spirit of public financing. So, so it's a difficult matter, but I based on the fairness of the spirit of public financing, it has been operating fairly well for the last, 14, 15 years. So I said.
Commissioner Rennie?
Yes, I want to say, as a big proponent of public financing, I have a lot of trouble taking a position that because of what candidate or some have called a technicality, that they lose their opportunity. On the other hand, as Commissioner Lee said, there has to be rules in the game. And in fairness, everybody has got to abide by those rules and be treated the same. Now, if this were a matter where there was some ambiguity in the requirement, I would bend over backwards to come up with a solution that would hopefully allow the candidate to get public financing. But there is no ambiguity about a requirement that a certain document must be filed by a certain date. It can be filed months before, but you're told if you don't get it in by that date, no matter how good your campaign is and how good your cause is, you can't get public financing. And I don't want to be, it's not a bureaucratic thing. When we had the the candidate for Mayor Alioto, we gave her a little leeway. I think Commissioner Kopp was the one who proposed giving her a little leeway, which she didn't meet. Even after we gave the leeway, she didn't meet. So she never got the public financing. But here, we're talking about failure, and from day one, the candidate says, I have filed the statement of participation. Said that in February. So I will support the recommendation that the appeal be denied, but I do it with a not a happy vote. But I think I have no other choice because I can't find a way in which I can be responsible to my position to say, well, I really want everybody to have public financing and the heck with the rules. I just don't think that's fair.
I share the sentiment of the commission. When I went back through the materials, it's very clear from the website, from the brochure, that there are two things that you have to do: the statement by the date that the nominating papers are filed, and then the later date for qualifying. And I am concerned that if there is a perception that if you have a problem or an issue, that people will think that those deadlines are not real, and that the commission somehow has the ability to just forgive deadlines. And I think that because it is a code requirement, we can, and because the information was out there. I do think in our next agenda item where we talk about public financing, that we need to learn from the difficulties that are brought before us and try and improve the system. I like the suggestion of the software person that they wouldn't be able to file their form saying that they had filed the other form if they didn't actually file the other form. I mean, I think that in this age of technology, we can make things more, sort of foolproof, as it were. But in the meantime, unfortunately, we are left to apply the rules, and it's clear that this candidate didn't meet that requirement. So I would support the motion.
So on the motion that's been seconded to deny the appeal, all in favor?
Aye.
Opposed? So the motion to deny the appeal is unanimously approved. Next is Trevor McNeil, supervisorial candidate for District 4.
Hello. Thank you very much, Commissioners. Good afternoon. My name is Trevor McNeil. I am a candidate for District 4 Supervisor. Thank you so much for having me here today. Just to give you a little background about myself, I'm a public school teacher, father of 3 under 3, and a native San Franciscan. And also, I think, as you may know, 1 month and 2 days ago, I was not a candidate for District Supervisor. This is all pretty sudden, and that is the nature of my appeal before you today. To give you a timeline of that appeal, on June 18th, I successfully submitted my nomination papers, candidate statement, Chinese name, Form 700 to the Department of Elections. We completed all these tasks in a 4-hour window. I intended to apply for public financing. That was always my intent, but I was not informed that I needed to submit a statement of participation that day. I explicitly asked the Department of Elections if I needed to run across the street to ethics and file things, and was told that I could wait until later in that week. Without a professional political consultant on my campaign to tell me otherwise, I took the staff's word and unfortunately missed the deadline for public financing, as did 3 out of the 9 of candidates for District 4 Supervisor. I did not receive an email on June 14th, as staff mentioned, because I was not a candidate at that time, and it was a weekend. I couldn't pull papers. On June 25th, I was informed that I had missed the deadline for statement of participation and rushed to submit my form and to file the appeal that you have, I believe, in your documents. I was informed the next day about my ineligibility and filed my appeal. It is clear, considering the number of candidates in the specifically the District 4 race who were affected and made the same mistake, that there is some problem with the public financing application system. It is a process that can only be navigated by a candidate with political consultants and the amount of time that we just didn't have, considering the unique nature of the District 4 candidacy. To successfully apply for your statement of participation, a candidate must open a NetFile account online, submit paperwork to open a campaign file with the SF Ethics, then submit paperwork to get the electronic signature verified, then connect the committee to their user account, and then finally search to find the correct form. And these were things that I could not do on that day with that timeline. As you know, the race for District 4 is unique, and due to the incumbency, the remaining process nomination window was extended. Even if you believe the application process of public financing is not substantive to this appeal, the deadline for the statement of participation is also inconsistent, I think, with the letter of the law. The law is clear that a statement of participation must be filed by the last day of the nomination window. However, the law is not clear about when that last day of the nomination window was. The Municipal Code, Section 205, says a candidate for mayor and the Board of Supervisors must file their nomination papers no later than the 147th day before the municipal election. There is no language about a deadline extension when an incumbent fails to file. The code explicitly says that other city elected offices should follow deadlines established by California Code 10220, which does have a provision that candidates that creates deadline extensions for an incumbent does not file. However, the Board of Supervisors candidates are explicitly left out of that timeline. When the Director of Elections announced in the press, not online, it wasn't updated, that he would extend the nomination deadlines for District 4 to June 18th, the deadline seemed to contradict the elections law and the California Code, as June 18th is not a 5 calendar day beyond the nomination period. I did all my papers on the very last day, which was a Monday. I couldn't even pull papers on Saturday or Sunday because the offices were not open. The Ethics Commission staff has always been very professional and courteous to me, but I'm aware that they were moving offices at the time The elections department staff has always been very kind and courteous to me, but I'm aware that they were in the middle of a major mayoral ranked choice vote count, and things were hectic, and things, for me, also were confused and overwhelmed. It is not clear that the statement of participation was actually due. There is some leeway that candidates who attempted to file their statement of participation but did it too late. We, as candidates, are told to refer to the Elections Code to understand our requirements. We do this to find the local elections code might contradict the state code, and then might even be ignored. The elections website wasn't updated with the new nomination deadline for District 4 Supervisor, and candidates cannot be expected to be held to a requirement that is possibly contradictory. I'm only seeking an opportunity to qualify for public financing. That's it. If I can raise the required amount of money, and that's from the required number of voters, I'll be back with those proper forms. I deeply regret the mistake I made in the public financing process. I believe the ultimate goal of public financing is to allow everyone who wants to run a substantive campaign, no matter what their background is or what institutional backing they come from. As a public school teacher and father of 3 young children, I believe that the law was intended exactly to include people like me. I'm asking for the opportunity to be eligible for public financing, especially if I'm able to raise the qualifying funds from donors in San Francisco. Without public financing, it will be very difficult for my campaign to be competitive against other candidates who have robust institutional support already. Our democratic society and government are strengthened by public financing, which helps voters become aware of the candidates. I appreciate this opportunity to appeal the decision today, and I hope you will grant me the opportunity, just the chance, to qualify. I think that there were, as Commissioner Rennie mentioned, there was some ambiguity in this District 4 situation. And with the offices not being open the 2 days prior to the nomination deadline closing, with the elections department explicitly giving me some information, I find it confusing that they have a checklist. In the elections department, they have a checklist of things you need. One of those does include an ethics filing, Form 700, but the 510, the 401, that they said I could file later, and they were correct, but they did not tell me that there was this other form that was due that day. And the second I found out about it, I immediately rushed to fix it. And so did 3 other of the candidates for District 4. So thank you very much.
Commissioner Kopp.
How'd you find out about it?
I was told by a friend who saw it online because
word of mouth.
Yeah. And
All right.
which was also the way I found out.
Let me put on the record that I've known Mr. McNeil for a couple of years. He states this is the first time he has run for the Board of Supervisors.
Right.
He did run for the Board of Education when I had my First Amendment rights in city elections, and those are not financed by taxpayers in any way.
And it sort of it does speak to, sorry to interrupt, it does speak to the I think the key part of this, which was I knew there were things that ethics needed to get filed at the beginning of a campaign. And that's why I specifically asked the Department of Elections, do I need to run across the street and do any of this? And they said I could do it later.
Let me finish.
Sorry, sir. Thank you.
My mea culpa. And Mr. McNeil did send me an email, I guess last month, saying I've been denied public financing, and I think I responded saying that you can file an appeal. Okay. And we've had no further communication since then. I say that because apropos of Charlie Marstello, who's departed, we are a quasi-judicial body, and I've had 3 communications on another appeal here, which are improper in terms of receiving and paying attention to such communications as a member of the Ethics Commission. Thank you.
Let me ask the staff a question. If you know the answer, when somebody files with the Board of Election their intention to run for office, do they get some packet of material from the Board of Election saying, here are the things that you've got to have filed by whatever the cutoff date is?
Yeah, in advance of this hearing, I did check in with the Department of Elections and to see what guidance they provide to candidates who file with them. And they were very clear with me that they only provide guidance to candidates about election-related rules and guidelines.
So they don't provide the form intention to participate in public finance?
They were very clear with me that if any candidate asks them about any ethics-related filings or any public financing-related filings, they just simply direct those candidates to consult with the Ethics Commission.
So that if a candidate at the last minute goes down and files his intention to run, say 4:30 in the Board of Elections office, there's no way he could ever or she could ever qualify for public financing, right?
It's my understanding in those kind of circumstances, they would direct the candidate to call or walk over to the Ethics Commission's office as soon as possible on that same day.
Yeah, but it's the last minute.
Yeah, if there's any...
Or consult the
But he
Ethics
said
Commission website.
But he said they didn't tell him that. They didn't tell him anything. It'd be, you have to ask, you're saying, if they asked us, I want to do public finance, well, you have to go over to the Ethics Commission. But if he doesn't say anything, they wouldn't tell him anything, right?
Right. I mean, for a lot of candidates, how this is going to work is that during their candidacy for different issues, although interrelated issues, they will have to consult separately with the Department of Elections about elections-related matters. They will have to consult with the Ethics Commission about campaign finance-related matters.
So did you, when you decided to run for office, did you think about public finance?
Oh yes, oh yes.
Huh?
I'm a dad and a school teacher. I don't have any kind of financing capabilities on my own. Public financing is the only way I can do this, and so because as Commissioner Kopp mentioned, I have run for things before. I knew that there were things to do at ethics, and I was explicitly told that I could do it the other day. And the Department of Elections does have ethics forms. They have the Form 700 about your what's the name of that? It's the money you own, stocks. I don't own any, and so I think that's going to the next item on your agenda. That is a place where that checklist does exist. That knowledge does exist. It begs the question, and I know it's not it's a spirit of the law versus letter of the law thing, but I don't even understand, going to something you were discussing, the purpose of saying, hey, I intend to apply for public financing, especially because of the nature of this nomination period extension. I applied literally I finished my process at 4 o'clock on the last day that you could do it. So no candidate was going to change their electoral strategy based on my announcing that I intended one day to participate. And by the way, I also find it very odd that the form isn't just an affirmative intention, it's also a negative intention. Like you have to say, you say whether you say, yes, I do intend, or you click affirmatively, no, I don't intend. Right. And if it is that binary, it should be a requirement. I shouldn't be, if I'm forced to declare my taxes and my stocks and bonds affirmatively. That's something they ask you to do. There are other things that in the onboarding of candidates, and again, I say this as somebody who was there all by myself in a sort of rushed place. There are other things that are optional. It is not required that you have a Chinese name to run. However, you are asked, do you want to have a Chinese name published? It's not required that you have a website published in the voter thing, but again, it's a sort of a proactive, affirmative checking in as they're going down this checklist. So again, the department was in the middle of this recount. It was the last day of this extension. I think there is a good chance that people were suddenly caught off guard. I certainly was caught off guard days later when I found out that all I needed to do was to check this box to participate in public financing. And I think that the purpose of public financing is exactly this moment of somebody who's took a chance, who has great ideas, I think, who is qualified and wants to communicate with the voters. And there are people who have already raised 3-4 times as much as I have who did check the box, which means that my government is going to give them double that money, so they will have raised 6 times as much as I have. And in such a truncated election window, which is why I do think District 4 is a little different, I'll never be able to make up from that. I wasn't alone. There were 3 out of 9. Earlier, staff was giving you percentages. I think District 4 is a little different. I still think it's confusing about the 5-day extension and why those days included days that the Ethics Department and the Elections Department were closed. I was not able to pull papers on Saturday. If I wasn't able to pull papers, I wasn't able to start the process. If I wasn't able to get a 501 or a 410 form from the Ethics Department, I wasn't able to get a net ID on Saturday or Sunday. So there was a confluence of things happening. I take responsibility for not having asked the right questions about public financing, but I think that everything in the District 4 situation was what it was. I appreciate that staff sent an email on June 14th to the treasurers. I didn't have a treasurer at the time because I didn't have a committee at the time because I wasn't a candidate at the time. I think that there was a lot happening in there that makes this appeal valid. There have been appeals in the past. I think that this moment in District 4 is special, and that this is exactly what public financing was designed to do. All I'm asking is for a chance to qualify. All I'm asking is for a chance to qualify, and I thank you very much. If you have any other questions, I'd be happy to answer them.
Any other questions? Other questions? Commissioner Lee?
Thank you, Madam Chair. Just want to ask the director a couple of questions. You mentioned earlier that after the Department of Election extended District 4 and 8, right, 4 and 8 to the 18th, the commission put out additional information through our website for the new candidates of the requirements. Did I get it right?
It is. Go ahead.
Oh, an email was sent on June 13th, which is when that deadline was extended. So we notified the candidates in Districts 4 and 8 that the deadline for filing the statement of participation was now going to be June 18th, so that they knew they had more time.
But you had to be a candidate.
Exactly, because in order for us to have
On
your
the 13th,
email address
right.
in our list of candidates, you had to have declared at that point. So candidates who declared after June 13th would not have been on that email list.
So were they still able to get the information if they were to visit the website, the commission website, that by the 18th you have to file your intent? Was that information?
I believe so. Yeah, I would have to look with the person who maintains that to see if that specifically was changed on the 13th.
So unless you announce right away, because the deadline was announced on the 13th, on the 13th. So unless you decided right away that you wanted to run, the rest of them did not get the information. But according to the form that you gave us, there were 6 candidates from District 4 who filed after the 12th, right? So I would assume 6 new candidates after the 12th. And of the 6, 4 of them qualified with the timely filing of the statement. So 2 did not file.
I believe it was 3. One of them has
3 dropped out. Yeah, so I did not count. Yeah, I did
not
not count her. So she withdrew. So is that correct?
I'm sorry. What's your question?
So there were 6 candidates who announced after the June 12th original deadline. Was that right?
I think there are 5.
5.
Well, I counted the person who dropped out. Okay.
Oh, right. Okay.
Okay.
Yes. So 6.
So 6. And of the 6, 4 of them, no, 5 of, no. 4 of them met the filing deadline. Is that correct?
I think it was just
Kinda-
3, so it's 50%.
3.
No, 4.
I counted 4.
Yeah.
Oh, I'm sorry, I did have 4. Yeah, because I counted it.
I'm seeing 3 of the 5
Okay.
candidates who declared their
Okay.
candidacy after
Okay.
June 12th filed timely statements of participation.
Okay.
Your report shows 4
Yeah.
that filed on the 18th.
Right.
Isn't that correct?
That's what I have.
That's what, in your revised statement that you handed us, 4 of them filed on the 18th and
But-
were accepted.
Correct, but my understanding was that Commissioner Lee was only asking about individuals who filed their candidacy after June 12th, and one of the individuals who filed their statement of participation on June 18th filed their candidacy on June 11th.
Oh, okay, thank you. I didn't notice that.
Oh, okay.
Yeah.
Right, the column, the third column shows the date that they filed for their candidacy at elections, and then the 5th column is the date that they filed their statement of participation.
Right. So there were 3 candidates who declared their candidacy and filed on June 18th, and who also filed their statement of intent to participate in public financing also on the 18th.
That is correct.
The other 3 did not.
And my understanding is that Art Tom, Trevor McNeil, and Lee Lovett were 3 candidates who did not make that public financing click. So 3 out of the 6 after the email was sent on June 14th to
Right.
register candidates.
Lee Lovett has withdrawn, so
Right.
we weren't counting.
Right, exactly. But I think she was in the process of becoming a candidate, as it was I. And for me, I'm just trying to make the point that this is a special circumstance. So,
I think, may I?
Oh, yes,
question?
Commissioner
Your point, though, about the extended time is that it included a Saturday. So in effect, but you got an extra day. So it wasn't from the 12th to the 18th, there were 6 days, not just 5 days, because the law usually, if a deadline falls on a weekend, it goes over. So you had 6 days to evaluate whether or not to file. And I actually, because I am a new commissioner, I attended the training that they offer for candidates in their campaign, and where they emphasize you have to file a statement of participation. And there's this document, the guide to public financing. So if public financing was so important to your decision to run, were you not able to get to the website? Was it not clear? Because it says right here, it's like really basic. Step 1, step 2, file a statement of participation no later than the deadline for filing nomination papers. So when I first saw these appeals, I was concerned, like you, that it was really ambiguous and nobody knew where to go or what to do. But I think that the staff has done everything they could to, I mean, it's a lot of information, but if you really want $250,000, you would read all of the stuff and make sure that even in the short period of time that you have, I feel really bad that it's not easier, but it's not.
It's prohibitive, is I think what I'm trying to say. It's actually prohibitive. They did not update the website with the new filing date. At some point somebody said the staff did their due diligence. I'm here trying to take as much responsibility for this as I can, but also saying I was given different information by staff, and it's
not by the staff of the Ethics Commission. You didn't contact the Ethics Commission, correct?
I did not. I asked the Department of Elections, who gave me Ethics Commission forms, if I needed to go across the street to the Ethics Commission, and I was told no, I did not, and that was the heart of this mistake that happened.
Right.
And I appreciate that there's a candidate thing online, but there were other things that weren't online. I read about the extension from Director Arnst of the nomination deadline in the Chronicle. I mean, there were communication things happening. If you go directly by the book and you say, the nomination paper, it says and I've read it since then because I've been trying to play catch up. It says the nomination date, but the website itself still had the old date. I mean, it was a confusing moment, and I'm begging you to consider this, because if you can only run for office if you can have this sort of unlimited time, professional help, it's clearly not in the spirit of the law. And I beg you to give me a chance to just qualify for public financing. And again, the form itself, the fact that you have to say yes or no, it's not intuitive. There were so many other things that I had to do on that day, and I was told I had to do on that day by staff that were more intuitive. The idea that I had to proactively say I intend to one day apply for something, it didn't occur to me. It'd be like saying to a 14-year-old, you have to tell the DMV on your 14th birthday that when you turn 16, you're going to apply to get a DMV license. I mean, it feels like that now when I look at the actual candidate form. I hadn't attended a candidate training. There was none offered on the one day that I had pulled nomination papers and was a candidate. And I beg you to give me a chance to qualify for public financing. That's it. And I really appreciate the chance to be heard.
Thank you. Any other more? Thank you. Public comment?
Hello, Commissioners. My name is Jay Chang. I am a supporter of Trevor's. I'm not on his campaign or anything like that, but I am a supporter of Trevor's, and I was here for moral support, but I felt compelled to just bring up a couple of issues for clarification that I thought were relevant to this and my support for him in this appeal that might have been skipped over. The first is that I think Commissioner Ambrose brings up a good point that there were 6 days from the date that the incumbent did not file to Monday. However, 2 of those days were a weekend. And in order to file the statement of participation, you must do it online, which requires you to create a NetFile account. Creating the NetFile account requires you to submit a signature verification form in person with the Department of Elections, which you can't do on Saturday and Sunday, right? Which is one of the reasons why you're not actually able to file the statement of participation over the weekend or before you make the decision to be a candidate, right? In fact, if you look at candidate Gordon Marr, what I suspect is that after he filed at the Department of Elections, he ran over to SF Ethics and then had to go through an entire process there that ended up him actually filing at 5:45, the end of close of business, right? Because he had to take the close of business in order to set up the NetFile account itself. Also, I want to bring up to Commissioner Rennie's point, which I thought was sympathetic, that you do in the support of public financing, and if there was any vagueness in the actual nomination deadline, that you would consider that vagueness as important. Now, obviously, that vagueness does not exist in the D6 race, but I do believe that vagueness does exist in the District 4 race. The SF Municipal Elections Code is very clear that the filing deadline, the nomination deadline, is the 147th day before the municipal election. It's also very clear that there's no extension for an incumbent if the incumbent does not file. They have no language such as that, right? In fact, they imply that there is no extension because the next paragraph says that any other city elective office, the deadline should refer to the California Elections Code, which has the statement about the 5-day extension if you do not file for an incumbent. So in this case, local elections code and state elections code actually directly contradict each other. And when John Arntz extended the filing deadline to Monday, June 18th, which is both not in the local elections code and not actually 5 calendar days after the deadline as prescribed by the California Elections Code, right? He created an artificial deadline that doesn't exist anywhere. And thus, if we were to say by the letter of the law, the nomination deadline has to be whenever that is you have to turn in your nomination paperwork. Sorry, the statement of participation deadline has to be whenever you turn in your nominations paperwork. That date is actually not clear if I read local elections code, the California Elections Code, and the director of John Arndt's statement. And I feel like that's a relevant point, that if the code is not clear, and that is a very complicated code in itself and a very complicated contradiction that I believe the city attorney does not even have total clarity on. then it's prohibitive to ask a candidate to also be able to follow that line of reasoning and determine what the correct nomination deadline is. Thank you for your time.
Thank you.
Afternoon again. My name is Stephen Buss. For the same reasons I supported Sonia Traus's appeal, I also support Trevor McNeil's appeal. The rules are a little too strict, and this commission should accommodate difficult circumstances like what was described earlier. We shouldn't hew towards arbitrarily strict rules when the ultimate goal is public financing, to make it easy for people that are not part of the political machine to run for office. So I urge you to grant his appeal.
Thank you.
Hello. So I'm the fourth one. My name is Uzuri Pease Green. I'm actually one of the candidates, but I decided to come up here because this is kind of crazy. So I have never run for office in my life. I am 52. I'll be 53 on Monday. And I was listening to the gentleman, and I know the issues that I've gone through by missing the deadline, even though you think you've made the deadline, but now you've missed the deadline, and all these different things that come up in between. One of the suggestions that I have is this. Take all the paperwork and put it all in the same packet. So when you go to that one place, when you go to file your intent, because I filed my paperwork on June 12th, and I filed it on June 12th on purpose, which I'll talk about later when it's my turn. But right now, I just want to say put all the paperwork in one packet, because it is one of the most confusing things to have to go over here and file this set of paperwork, and you think you filed this set of paperwork, but you miss one piece of paperwork. And who in their right or left mind would not participate in participation funds, especially if you have no money? I don't have any money. He's a teacher with 3 kids. I know he doesn't have any money. So therefore, of course, we would want to participate in matching funds. And so that should be something that should be a lot more simpler. And just like you extended it that one time to Angela Alioto, but she didn't make the funds, so why not give that same extension? You have to look at when your woman is pregnant and the doctor says your baby is due on June 11th, yes, we get a little mad because the baby doesn't come out on June 11th, but you cannot always be a firm, have this 5 o'clock, this is it, because there are circumstances that come into play, and so you have to give yourself some type of wiggle room to actually look at those circumstances. Thank you.
Thank you.
Hello, I'm Milo Traus. I support this appeal, and again, I think it's a reflection of our matching funds, our compliance, our ethics, disclosure system does not do what it's designed to do. And we're arguing about deadlines. Did we meet the deadline? Do we not meet the deadline? We have the technology to not even have deadlines. This shouldn't be a thing. We could have bank accounts that are open and connected to a platform. As soon as a donation comes in, everyone sees it. It's flagged as somebody who lives in the city and county of San Francisco, so it's eligible for matching funds. It could be a lot easier and smoother. And NetFile, I don't know if any of you guys have used NetFile. If you've ever logged onto it, it is a disaster. Independent of this appeal or the appeal before it and how it came out, this is something that I've been interested in since I've started working in politics. It doesn't work, and we need something better that's easier. So I understand that's the next item. I don't know if I'll be able to stay for it, but you guys should take a hard look, I don't know if you have staff, and develop some sort of proposal to move us away from what we have existing to something that is streamlined and easy. We can use blockchain. There's just a lot better systems we can set up than what we're using today. And we can see that it's not working for our democracy. It's causing problems. And here we are in the center of San Francisco, where we will develop the forefront, the things that other democracies will look towards to function healthily and productively. Thanks.
Thank you. Any other public comment?
Charlie Marsteller again, for the record, and I wanted to say two things. One additional point as to why the commission follows such strict rules is because public funds are involved. I think we don't mention that enough. I think that it's kind of like an elephant in the room. And there is a tremendous accountability issue that is key to PF. It's got to be you're trustees of public funds, and that I don't think is impressed enough. And you are striving for proactive and concurrent and audit and enforcement. I know that. And we're getting better at that. The second thing I wanted to answer, the last spokesperson or speaker talked about improving the process, and I think the Seattle voucher system, we'll talk about that again, but the Seattle voucher system may solve a lot of the complexities in qualifying individuals to make sure that we know that they are residents of the city, for example. So we'll talk more about that in a minute, but I think there are many remedies that we can discuss in our next meeting, agenda item.
Thank you. Any further public comment? No. All right. Is any commissioner like to make a motion? I would just like to, before we go there, to thank Mr. Marsteller for his comment. That's one of the things that was going through my mind as I've been listening through these two appeals, and that is public financing is a vital part of the political landscape here in San Francisco, and we're very fortunate to have it. But as members of the commission, I think it's important that we bear in mind that these are public funds, these are taxpayer dollars, and that there are rules and regulations and procedures put in place in order to allow for the fair and predictable administration of the dissemination of those funds, and that there's a qualification process. It's not an entitlement; it's a privilege. And so, as many speakers have alluded to at our next agenda item, we will be taking up commentary and hearing a presentation, and also taking public comment on how the public financing program can be improved, and there's a lot of food for thought that has been presented here today. But I think that it's, mistakes were made, I've heard that a lot today, and that we should make an exception, but the regulations and whether they make sense and whether or not they can be improved is a separate issue, but the way that the law exists today is that the forms need to be filed by a certain deadline, and that's the gatekeeper in order to qualify to receive these taxpayer dollars. And I think that that is very important for us to remember as we consider these appeals. So,
I will make a motion that we deny the appeal.
There's a second. All in favor? Aye. All opposed?
No.
Okay. The motion carries 4-1.
Some candidates got special.
Madam Chairwoman, would you please enforce order in the hearing room?
So, I'd like to call Arthur Tom.
Good afternoon, Commissioners. I'm Arthur Tom, candidate for District 4. I echo a lot of the things that have been said, and I know you have my appeal written down, so I'm not going to belabor the point because you've been here a long time listening to this, but there are a few things that I saw through this that I wanted to point out. One, on January 13th, when you claimed that there was a notice that went out, I was not even a declared candidate at the point. You had no way to notify me. I received no notice, of course, from the department, from the Ethics Commission. I couldn't have. The first notice I received was actually June 26th that I was ineligible. I went in on, in the middle of the day on the 18th, which was a hectic day, the Department of Elections went through a checklist. In no way did they tell me anything about public financing. I found that out later just through somebody I knew that had gone through this before. This is my first time I've ever run for public office. And so I still didn't know what the deadline is, but I went over as soon as I could to the Department of Ethics on the 20th, which is 2 days later, and I want to come back to that later because 2 of the days of those 5 days was a Saturday and Sunday that I had no access to the Department of Elections or the Department of Ethics. I had no way to have a full 5 days. And when I went in there, to my shock and horror, I found out that they said one of the staff people in the Department Ethics Commission said that the deadline was actually the 18th. And that was my first hearing of it. So I said, I'm going to apply anyway. This is the first I've heard of it. So you can see by the date stamp I was on the 20th, 2 days late. And I feel that the time that the place was closed and in the hurry-up campaign, because there was only that 5-day extension, there was almost no way to get all the petitions signed and do everything that it said for the Department of Elections, much less knowing about public financing. And it's evidenced by the fact that it was claimed there's a 75% success rate in people applying. I think public service is one of the highest things you can do. And let's say something that's not as important, like graduating from the 8th grade. If 25% of the people failed, that would be horrendous. But in this case, 25% of the people trying for this did not make it. I want to think that we're all trying to do the best that we can. We're law-abiding. I need to have the money. There's no way I can afford anything like this on my own. I'm going to be completely dependent on public financing. Without it, I can't be part of this democratic process to effectively compete against people who have that. And I couldn't even get a campaign manager to give me advice because they said, why don't you get public financing before we know we can get paid? Sorry, I'm not going to talk with you now. I came across that closed door several times. Even other groups said, I don't know if I can contribute because I don't know if you're going to get public financing. So I'm at a disadvantage right from the start. And it's not although this is the first time running, I was looking at this position before, and I was actually a distant second, if there even is one, to be considered for appointment by former Mayor Ed Lee, who ended up appointing the legislative aide for Carmen Chu, which is Katie Tang. And this is the first time that the district's had a chance to have a homegrown grassroots community leader like myself have a chance to come up. So when I saw that, I wanted to do everything as soon as I could. And through that, the hurried rush and everything like that, I did not know about the public financing until 2 days later, and I went down. Whatever I was doing, I went to the Ethics Commission that day. And I'm saying if there's any technicality, the weekend days that it was not open should be considered as the time that I could make up for it.
When did you decide to run for supervisor?
You know, I had thought about it for years, but to run against an incumbent is just unlikely. So when it was announced, to the shock of me anyway, that Katie Tang was not going to run, I looked at it that very day, or the next day, because I didn't find out about it till the next day.
But when you felt that public financing was the only way you could mount a campaign, you didn't make any investigation as to what was required to get public financing?
I did not have campaign advice. I did not have a strategist. I I didn't know that the availability of it was going to be required on that same day. As a matter of fact, when I was in the Department of Elections, I said, am I doing everything right? Am I doing everything that I'm supposed to? And they said, yeah, just turn in these papers. There is a Form 700 where you have to write your financial background. There was petitions. They didn't say to go to another building in another place and apply for public financing. I didn't know that. I'm the exact person that this type of program is set up to give a chance to play on a level playing field with. And because of my being a neophyte, first time running, it's doing the exact opposite. And you here as a commission can make that change today. And that's what I'm appealing for, a chance for democracy, the San Francisco way of letting people have a chance to represent their community.
Any other, Commissioner Comp?
Well, just I want to put on the record that two people telephoned me to urge me or to acquaint me with the fact Mr. Tom was running for supervisor and to urge me to grant his appeal. And I think, Mr. Tom, you telephoned me, and then eventually we spoke when I called you back and said, have you filed an appeal? Is that correct?
No, that's correct, but I in no way asked these other people. I did not even know that one of them called. I in no way said to do anything, please, to do anything that's unethical on the commission. I just wanted to know what was going on and how I should proceed.
Okay, thank you.
What day of the week was the 18th?
18th was a Monday,
Monday?
and the 12th was a Tuesday. So there were 3 business days, the 13th, 14th, and 15th, the weekend, and then the 18th was the final day deadline.
So that the requirement to file the candidacy was on Monday.
That's correct.
And Mr. Tom's statement of participation was on Wednesday?
No, it was also due on that same Monday, the 18th.
Right, it was due on the 18th, but it was filed on the 20th. It was filed on the 20th.
Yeah, Mr. Tom did not file the statement until the 20th.
Pardon me?
Mr. Tom did not file the statement until the 20th.
That's what I say.
Right, that's correct.
20 days later.
But also, Madam Chairwoman, just procedurally, it should be noted for the public that an erroneous statement was made in the last matter by one of the witnesses in support of the appeal, that there was something irregular about making Monday the 18th the deadline.
Yes.
Because 5 days ends on Sunday for the information of all who might be interested in this minor subject matter. The California Government Code has a general provision that if something's supposed to happen with government agencies and fall by a date which falls on a Saturday or Sunday, it is extended to the first Monday after Sunday.
Right, so the 5 days.
Nothing irregular about June 18th.
So the 5-day extension fell on Sunday, June 17th, and therefore was extended to Monday, June 18th.
Right.
And that was completely ordinary course. Okay. Commissioner Lee? Oh, no? Okay. Any other questions from commissioners? Thank you. Public comment?
Good evening. As I stated before, we should be making participation in public public financing easier. And if we're not going to do that, why are we here?
Thank you. Other public comment? No. Okay. Entertain motions at this time?
I guess consistent with the position that I've articulated, although reluctantly, I would move that we deny the appeal.
And I would second that reluctantly.
All in favor? Aye.
Aye.
Opposed?
No.
Motion carries 4-1.
I think what these last two have highlighted is that we probably need to have, in connection with public financing, some change to allow candidates who at the last minute decide that they want to run and obviously are not political insiders, that there is some period that they would have in which to comply with the requirement. But as the rules now stand, the answer is, I think, has to be no.
So I think our next agenda item would be a great opportunity to take that up, and I would agree that we have a wonderful opportunity before us to improve the public financing program, and that we will seek the input and comments from staff, as well as invite candidates and those from the public to participate. But this is difficult, unfortunate, and I think that we are all very sympathetic to the challenges facing candidates. But as the rules stand right now, there's not much leeway, I think, in terms of enforcing them, simply because it's a filing requirement, and it is, as Mr. Marcelo pointed out, public financing. These are taxpayer dollars that we're dealing with, and that the purpose of creating a regime and procedures around those, imperfect though they may be, are the ones that we are bound to follow at this time. So last but not least, I'd like to invite Ms. Uzuri Peace Green.
Hi. So I just want to say on the record that if you know that you have these guidelines, then by right, you should have just not even had an appeals process. You should have said, look, this is the rules. We can't bend the rules. So it makes no sense for you to come here, spend all this time here, for you to just get denied. Because like the other gentleman before me and the lady, we all went through the process like we were told and like we thought that we were doing. I hired a campaign treasurer so I wouldn't be standing here looking at you. But again, my campaign treasurer dropped the ball. I have never run for office or anything like that. And yes, I told the Ethics Commission that I wanted to do the matching funds, told my treasurer I wanted to do the matching funds. I live in Patrol Hill Public Housing. Do you think I have any money? No. So I definitely want to do matching funds. I was told that my campaign treasurer is the one that filed the paperwork. So then when the paperwork got sent to me on June 20th, I immediately signed it and sent it back. Then I don't find out until somebody tells me about it being in the newspaper that I don't even qualify. I purposely filed on June 12th. Why? Because that was my brother's birthday, and he turned 50 on June 12th. So therefore, he turned to half a century. That's when I filed my papers to even be put on the ballot at that time. Is there any paperwork that I need to do? Is there anything missing? No, there's not. So I'm thinking that everything is all fine and hunky-dory until this newspaper article comes out. That's the only way I find out that I don't even qualify for the matching funds, because this email that you guys sent out on June 4th, first time hearing about it when I'm in this courtroom right now. And then the email that was sent out on June 26th, guess when I got that? After I called, yes, Johnny at the Ethics Commission is really good, but he's like one of the only ones. So if you don't talk to him, you talk to somebody else over the phone, you're not getting too much information. So therefore, I call, they put him on the phone, I finally get that email sent to me. Outside of that, I would have never even known about the matching funds and that I didn't qualify. So my whole campaign on my Facebook page and everything else has been about matching funds. I really think that it was really disheartening. I know it's disheartening for me. That's why I'm frustrated to come here. That's why I said it's like a check the box meeting, because you already knew that you weren't going to grant us our appeals in the first place. So instead of me being here, I'm supposed to be at a funeral. Now I'm not even at that funeral that started at 4 o'clock. Why? Because I'm sitting here because I'm the last candidate for a meeting that you weren't even going to grant the appeal in the first place. So that process, when like I said earlier, all the paperwork needs to be in the same packet. That is too much for people to have to go over here, go over there, and then you're trusting the campaign treasurer. That you're paying, by the way. And for my campaign, that's the only one that's getting paid is the treasurer, because I didn't want to go to jail. And I wanted to make sure that all the paperwork was in. But again, because the treasurer dropped the ball, we are all penalized. So I'm penalized, Sonia's penalized, these two gentlemen penalized, and hell, they didn't even, excuse my language, but they didn't even attempt to apply until at the last minute when they're competent. So at least you could have granted those two appeals. Even if you didn't grant mine and Sonia's, you should at least granted those two guys, because theirs was at last minute when they didn't even know that they were going to run until the incumbent dropped out. There has to be some type of wiggle room. You can't keep going by what is right there on paper. Because I just seen the last gentleman come in and get his waiver signed and okayed, and it's like, how does all of that work? And I'm like, wait, isn't that the same man that just said that we can't have our same appeal? So there has to be some type of wiggle room, because there is no way that a lot of us would not be doing the matching funds. And yes, you're right, that is public funds. I work a 40-hour plus job. My mother worked until she retired. My dad worked until he retired. My daughter works. My uncle worked until he retired. So those matching funds are my tax dollars as well. So therefore, I have put into those matching funds as well. And like I said, anybody in their left or right brain who has no money would definitely want to do the matching funds. I've been in the Ethics Commission twice, 2 times, because I had to go pay a fine. And nobody gave me that piece of paper to say, here's for the participation funds. So this is why I'm frustrated. Excuse me for sounding out there, because I'm like, come on now, seriously. It was like, it's very disheartening, and it makes you not want to keep going forward because of the fact of this. Now I'm going to have to really hustle, because I did not want to spend, I'm already said I'm not spending $100,000 on a campaign. That is crazy. I'm just going to tell you, that is crazy. You need to put a cap on that too. You need to make it where you only spend $50,000 on a campaign. For a supervisor, $200,000, $300,000, that is a lot of money. Do you know how much money, how much food you can buy with that? Come on now, that's a lot of money, even in matching funds. I was only trying to get $10,000 and get the matching funds at $20,000. That was it. So I've said my piece. I won't be able to stay here but really look at making it to where it's either linked to the bank account, where you automatically, if you raise $10,000, you get the matching funds. If you raise $100,000, you don't need the damn matching funds, because that means you already was able to raise the money in the first doggone place. But you make the matching funds to where at least it's where somebody can actually run their campaign, a really grassroots campaign. Thank you.
Thank you.
I have a question.
Commissioner Kopp?
Is your treasurer this
Yes, same one.
Dean?
Mm-hmm. Yes,
All
yes.
right.
Lord Jesus.
And she is a CPA?
A who?
A certified public accountant.
That's what I was told. She was recommended to me because
Did you
I
ever
wasn't
meet her?
No. I was never even going to have a campaign treasurer. I was going to have the
How
lady.
did you communicate with her?
Through emails and then phone calls.
Did you pay her a fee?
She takes her fee out of what I raise, and then if I haven't raised the amount, then she'll send me an invoice and she'll say, well, we're not going to take any fees out just yet until you raise more money.
Have you paid her any fee?
She's taken out a fee, yes.
4 figures, 3 figures, 5
Well, I
figures?
don't have 4 figures, and we're only talking about she charges me $250.
Okay, thank you.
You're welcome.
Thank you. Public comment?
I am so disappointed in this whole process. I'm at a loss for words. If you can't help people get public financing, what's the point? It should be our goal to make it easy. And when people make innocent mistakes, to say, that's okay, that rule is stupid, and we're going to change it, and you're fine. That's what we should do. In the next hearing, hopefully I have time to stay, we should make these intent to participate forms not necessary. You should opt everyone in by default and make it retroactive. San Francisco should be better than this.
Thank you.
This, the appellant here brought up a good point that this body earlier today made an appeal that affects one person, Jeff Sheehy, or granted the appeal. So you have discretion. That's the reason why you exist, so that you can see with the big picture what works, what doesn't work, and what direction we should be going. And so here, this decision, it affects the whole city when candidates who are going out or getting support can't participate the way they're supposed to. So, yeah, I think you've made some errors earlier, but here's one person who can still rule in the right way. Thanks.
Thank you.
I do, if you don't mind, I just really quickly, I know we're going to want to speak to that because I can see how disheartened people are. The difference between the waiver request from former Supervisor Sheehy is that the ordinance that the Board of Supervisors adopted, the Code of Ethics, gave this commission authority to grant waivers in cases of extreme hardship, provided that a finding was made. The ordinance that requires that you file a statement of participation no later than the date that the nominating papers are filed does not grant this commission discretion to give you an extension of time. And that is what we've been struggling with throughout this hearing, is that there is the law of public financing, which is a Board of Supervisors responsibility, did not allow for us to necessarily give extensions of time. And then there were other practical considerations about, if the information was clear, it wasn't ambiguous. And that is the reason why we have not been able to grant the appeals.
That's where your loophole is, because the information is not clear.
Madam
It's
Chairwoman,
Sorry, we can't
if
speak
there's
from
going to be a dialogue with a commissioner, I would ask that the participants address the commission in the usual fashion.
I think I just wanted to make that point, and there's no reason to.
But it's not clear. That's the whole point in the whole matter. If the purpose of you hiring a campaign treasurer is to take care of all the finances and the filings, and then when the campaign treasurer does not do that, then how is that clear for us who are running, who hired the treasurer in the first place to take care of the paperwork? That's the whole point in the matter, is that we're relying and we're putting our trust into somebody. The only person in the whole campaign that's getting paid is the treasurer. There is no campaign manager. Everybody is volunteers. That's the only person that's getting paid. I know that's the only one's getting paid in my campaign is the treasurer. So when you do that, then it's like it's like we're getting smacked twice. We get smacked by the campaign treasurer, and now we're getting smacked by the rule of saying that because we didn't check the campaign treasurer. That's the whole point in the matter. And so how can you be mad at, how can we be responsible if we call ourselves being responsible? That's it right there. We call ourselves being responsible by hiring somebody, because I don't know nothing about the filing. I know nothing about how to do the figuring or anything like that. So I hired somebody who's supposed to be responsible to do that. Not just myself, but other people did the same thing. So if we're putting our trust into that person, and that person's been in existence for over 17 years, like me personally, I'm like, you think you know what you were doing about a supervisor position, if anything else, let alone if you're taking care of mayoral candidates, you also should know about supervisor. So we're getting smacked twice. All four of us are getting smacked twice. And it's actually not right. You know, we're getting punished for something that we call ourselves doing the right thing.
May I make?
Yeah, yes, Commissioner Rennie.
Make a comment? Not necessarily to you, but somebody has to be held responsible. It's the candidate who's responsible. Now, if your campaign treasurer screwed it up, your fight was with her, not with this commission. Not the commission that caused the problem. It's your campaign manager. That's right. But I will say to the other comments that have been made about being frustrated because we have taken the position that we don't really have the power to extend the time when the requirements are quite clear. But I do think that the hearings today have been helpful for showing us there may be problems that we ought to try and fix so that there isn't a necessarily arbitrary way in which people are denied public financing. But clearly, telling somebody you've got to do it by a date is not an arbitrary thing.
All right. So to wrap this up, anyone have a motion?
All right, I'll make the motion
Okay.
to deny the appeal.
Second?
I can second that.
Second. All in favor?
Aye.
Aye.
Opposed? The motion's carried unanimously. That's the end of Agenda Item 6, and it's been at it for quite a while, so we'll take a 10-minute recess and reconvene at 5:45.
At what time, 1:45?
1:45, yeah.
Thank you.
SF Gov TV, San Francisco Government Television.
We're going to take agenda item 10 out of order because we have someone from the Bureau of Delinquent Revenues here to give us an update on the number of matters that have been referred to them to track down the monies owing.
Good evening. I promise not to take up
Is there-
time. Am I on? Okay. Oh,
Great.
yeah, I am on.
Yeah.
Appreciate your time. I won't take up too much of it. To give you some updates, and I don't know if it's helpful to have an overall overview of our general collection process or just delve right into the current status.
I think we can
Just delve right in?
dive right in.
All right, great. Oh, I'm sorry. So Jeff Smeichel, Assistant Director for the Bureau of Delinquent Revenue. So we have a total of 5 outstanding matters for the Ethics Commission, 4 different taxpayers. 2 of them, one of the debtors is Chris Jackson. Mr. Jackson, currently there are 2 judgments against him. And in both of those judgments, they're currently pending an order of examinations hearing. So what the order of examinations hearing will entail is after the debtor is served, they're ordered to appear in small claims court, and the collector will cross-examine them to obtain information on assets. So as of right now, the collector has made multiple attempts to get to engage him directly by phone and by email unsuccessfully. So the order of examination will require that he has to appear before the judge. And normally at that point in time, the collector prepares a number of questions to probe to find out financial or asset information. And that's currently set for August 30th. For Jacqueline Norman, same situation, so unsuccessful contacts. We do have a judgment. We also have an order of examination hearing also set for the same date of August 30th. For Isabel Urbano, this individual was on a payment plan agreement. They were keeping the agreement up until a few months ago where they defaulted. We know that Ms. Urbano is located in New York, so we're currently doing some asset research to confirm if she's going to be a good candidate for legal action as well. For Lynette Sweet, so this is the one who has the big kahuna. Lynette Sweet had filed for bankruptcy back in October of 2017. And since then, our legal section has been, well, actually prior to that, our legal section team had filed a lawsuit against her. She had filed for bankruptcy and has currently been going through a bankruptcy process. However, as of yesterday, they are progressing pretty quickly on a dismissal process for her case. So she filed for Chapter 13 bankruptcy, which is indicative that she has some assets and is required to do a repayment plan. So to provide the courts with total values of her assets and look to see how creditors can be compensated through liquidation of those assets. Due to non-responsiveness, her case is being reviewed for dismissal. The trustee had filed for dismissal, I believe, sometime late last month. They had a hearing about it yesterday. It's been approved to move forward, and they're going to have a final confirmation hearing. We're just waiting on to get that final confirmation hearing date. Once that has been passed, and if the dismissal goes through, we will resume our collection effort against her through our legal section team.
Madam Chair, can I just
Yes,
quick
sure,
question?
Commissioner Lee.
Do you know if Ms. Sweet is employed?
As of right now, I have to double check the records. I believe she is. I don't show a record that she was. So for us, we do show that she owns several properties of substantial value. So that's currently our basis for pursuing her legally.
I see. So if the case is dismissed, then it would then, the only recourse then that the city would have would be to go to pursue her through tracing her assets and then getting
So,
judgment, a lien.
Yes. So if we're successful in suing her, we would definitely want to attach a lien against her properties, and it won't end there. So I mean, we continue to pursue for the life of the judgment. We have no problem renewing judgments. So they're good for 10 years. So we'll do them up to a total of 30 years. And we continue to research for assets during that period of time as long as the judgment's still viable.
Thank you. Any other questions for Mr. Smichael?
Yes.
Thank you for coming and
Yeah, not a
for staying
problem.
late.
You guys have a wonderful weekend.
you.
Public comment.
Anything
Oh,
further, let me
yes.
know. Okay.
Somebody's got their hand up.
Public comment.
By leave of the chair, I have shed my sport coat.
So granted.
That's an implicit leave of the chair.
I'll,
See, Mr. Shen sets the example.
I'll make this quick. I'm Charlie Marsteller for the record again. I did want to let the gentleman from BDR know that Ms. Sweet is a kind of a special case in my heart because she used public finance.
What? We
why
can't
don't
hear you.
speak up?
Oh, I'm sorry. She used public financing to a large extent, commingling funds between public funds that she received and other campaign funds. I can't parse it out here and now, but I would say that they involved public funds that were given to her to run for office in 2010. And we have reached a point now where I'm glad from your report that we seem to be very much on top of the situation. It languished for a while. But to me, I think it's a particularly poignant case given and much true to the public interest because we are supposed to have concurrent and proactive audit and enforcement, which we are getting good at now. And since there were public funds involved in this particular matter, I really do appreciate BDR's diligent pursuit of this matter. And that's all I wanted to say.
Thank you. Any other public comment? Mr. Pierce, did you want to go through the rest of the enforcement report? Just to cover this off, and then we'll get back to the regular agenda items.
Sure, I can do that, but I'll try to be efficient in the interest of time. I think, the bulk of the remainder of the report really just goes to the statistics of the enforcement program, as the report often does. And we note that, again, the average age of matters in preliminary review has come down to, I think we're at, on average, what are we at, a month and a half? And that none is older than, I'm sorry, I haven't reviewed these facts because we're taking this out of order, but the average age of preliminary review has come down. The average age of investigations has gone up only slightly. We're just over a year now. Again, that's on average. And you'll see in there a note that I make indicating that we have optimism that very soon a number of the oldest matters under investigation will soon close, which will both clear out, again, some of the cases that we have referred to as legacy, freeing up resources for more concurrent investigations, but also as a result of closing the older cases, bring the average age of matters in an investigation down. But chiefly, I would just like to thank the investigators for their diligence. They have tried to take the new complaints as they come and address those diligently. Obviously, we don't yet have the agility to address complaints during an election season. I know that we have indicated a need for conversation about how the enforcement program prioritizes cases, but using the method that we have used historically, we're making significant improvements. And again, I would attribute that to the diligence of the investigators.
Any questions from commissioners? Well, great work on bringing down the average age and keeping it down, and tell the team to keep up the good work. Okay. Back to our regular agenda, item number 7. Informational staff presentation and overview of the city's limited system of public financing for elections for city elective office. San Francisco Campaign and Governmental Conduct Code, Section 1.136 et sec, and associated regulations. Thank you, Mr. Smichael.
Thank you, commissioners. I will give you a PowerPoint presentation that gives a high-level overview of the public financing program. I will try and make it as brief as possible, but it is fairly detailed because I want to inform the process of review that is just commencing now. As you determined at your last meeting, a review of the public financing program is the Commission's top policy prerogative. So the purpose of this presentation is to give the Commission and the public basically a common starting place of understanding of this program, so that as we commence this review project, there's just some common terminology and mechanisms that everyone understands. So I will boot this up.
Printed that out, and where is it?
Pretty big one. They might have some more down
Yeah, I
there.
know that, but
Can you all see the presentation on your monitors?
Yes.
Great. Okay, so this is just an overview of what this presentation contains. So in the first section, I will talk about the goals of the program, why it was created. And secondly, I'll talk about how it's paid for. Obviously, it involves an expenditure of public money, so that has to be paid for through the city's budget. I'll talk about that. The second section, I'll discuss what candidates actually get in terms of public financing once they do qualify for the program. The third section talks about how candidates qualify for the program. What steps do they need to take to qualify? And then additionally, what steps do they need to take to get matching funds? And also for each step, I'll talk about what the deadline is. And then lastly, I want to talk about the spending limits because that's a major part of the program. It's very important to understand how this works as well. So I'll jump in. So firstly, program goals. The public financing program was created by Proposition O, which was on the November 2000 ballot. So I looked to the voter information pamphlet that voters were looking at when they approved this program, and drawing from the reasons and justifications that were provided there to help inform our understanding of what the program's goals are. The first goal or purpose for a public financing program that's listed in that voter information pamphlet is to incentivize candidates to limit their spending. So this was tied to the concept that there's a lot of money spent in political campaigns, and that by having public financing, perhaps it would lower the total amount that candidates were spending. I think in light of more recent history, since we are talking about 18 years that have elapsed since the public financing program was created, I think that we can add a corollary that reducing candidates' dependency on IE spending is a related and also relevant concern. Obviously, we can't seek to diminish IE spending because that's also constitutionally protected speech, but I think that having public financing available to candidates can make them less dependent, or reduce their need to have IE spending in their favor. So I think that that's something that, although not explicitly in the voter information pamphlet, because arguably IEs were not as much on the campaign finance radar in the year 2000 as they are today, I think that we can look to that as a program goal as well. So additionally, decreasing the amount of time that candidates spend raising money. Obviously, if candidates are able to draw on a public fund, at least in part, to fund their campaigns, in theory, they don't have to spend as much time trying to get private donations. So this frees them up to do other things that you think of as more traditional campaign activity, like speaking with voters, engaging in debates, that kind of activity. So another goal that's stated is to increase the opportunity for candidates to run for office. This is closely related to decreasing their dependency on private money. If a lot of candidates don't have access to fundraising networks, arguably that may exclude them from running for public office. So in theory, if they have access to public funds, this may increase the pool of people who are now able to run for public office. Lastly, ensuring the integrity of the electoral process. I think this goal probably had in mind that if candidates receive a lot of money from private contributors, that there may be an expectation on the part of those contributors that they will have access to the candidates or some kind of ability to influence the candidate if and when the candidate is successful and attains public office. So if the candidate has less dependency on private donations, perhaps they'll be less influenced by private contributors, and there will be more integrity in the electoral process. So additionally, I did want to include some of the purposes and intent of the campaign finance reform ordinance. Although these purposes that are listed in section 1.100 don't explicitly say they're the purposes of the public financing program, obviously that program is housed within CFRO, so I think we can infer that that program is also in furtherance of these same purposes and intents. So a few that are on point: reduce incumbent advantage, increase competitiveness. So this also goes to what we talked about on the previous slide, make greater availability of public funds to candidates. That means that perhaps there will be more challengers who can competitively run against incumbents who statistically have greater access to private contributions. Enhanced discussion of issues. This goes to also reducing the candidate's amount of time spent fundraising. Less time fundraising, perhaps that means more time discussing issues, more time at debates, community events, and then as a result of that, in theory, voters will have more information because they've been contacted by candidates. Maybe the candidate has time to go knock on doors and speak with people. They're having more information, they feel more confident. I would argue that they're more likely to vote if they've been contacted by a candidate. Restoring trust in government, one of the purposes of CFRO. I think this also goes back to the integrity of the electoral process. Okay, so there are your goals. Let's talk about funding. So the public financing program is funded out of the election campaign fund. This is a separate fund created by the city that solely funds this program. The way that the election campaign fund is funded is through a base annual appropriation. It's based on the number of residents. So for every fiscal year, $2.75 is appropriated for this fund per resident. So to give you an idea, if we assume that there are about 880,000 residents in the city, that would mean that the annual appropriation would be $2,420,000. And that money can roll forward subject to a cap, which I'll discuss in a minute. But that's the base level appropriation. There are additional appropriations that are triggered if a vacancy occurs. So if someone leaves office and there has to be a special election called to replace that person, there are additional appropriations to make sure there's enough money to have public financing in that special election.
So I'm sorry, Pat, to interrupt. Are the appropriations assessed automatically, even if, say, it's capped at, or it's at 6.8 million?
No, so they would still be, I believe they would still be subject to the cap.
The cap, okay.
Yeah, I think the cap
it's only assessed, there's only additional appropriations if necessary upon the occurrence of a vacancy?
Right. I think that was the idea, that if you're up at the cap already, you don't need these additional appropriations because there's enough money in the fund. It was more if the fund is dry, if it's been exhausted, and then here's an additional special election, here's an additional appropriation to make sure there's a minimum amount to be used.
And then you said it's capped, but it rolls over. So if the fund is depleted to $5 million at the end of the fiscal year, it'll still roll to the following fiscal year. We don't have to use it or lose it.
Right, but the appropriation will not occur if it would put the amount over 7. So, for example, so in your hypo, let's say there's 5 million sitting in the account. Then it's time for the annual appropriation, and let's say there's 880,000 residents. They will not appropriate the full $2.42 million because that would put it over 7. They would just bring it up to 7.
I see. Okay. Thank you.
Okay, so I will move on to the next section about the financing that candidates who qualify for the program receive. So public financing under this program occurs in 3 phases, and they occur in order. So the candidate goes through each one, you can't skip. So the first phase is a one-time grant that the candidate receives when he or she qualifies for public financing. For mayoral candidates, it's $100,000. And for supervisorial candidates, it's $20,000. So as soon as you qualify, you file a qualifying request, it gets approved, you are entitled to this lump sum right up front. Then at that point, once you've qualified, received your initial grant, now you may participate in the 2-to-1 matching phase. So you have to submit now additional requests for matching, and the matching is done first at a 2-to-1 phase up to a certain maximum. So for mayoral candidates, they may match 2-to-1 up to $425,000, meaning they can get $850,000 from the city to match that. And for supervisorial candidates, up to $50,000, so they can get $100,000 at the 2-to-1 level. Once you exhaust the 2-to-1 level, you move on to a very limited for mayoral candidates 1-to-1 level. So that's only $25,000. A little bit less for incumbents. I'll speak to that in a minute, but the funding schemes are a little bit different for incumbents and non-incumbents. And for supervisorial candidates, they can actually get $35,000 at the 1-to-1 level.
Can I ask a are we allowed to?
Yeah, absolutely.
Interject?
So interject, please.
Just on the issues that were dealt with today, somebody could have filed both the statement of participation back in February, not more than 9 months before November, but in February, qualified, filed their demonstration that they have $10,000 from, it's $10,000, right, from 100 different.
Right, for supervisorial candidates, that's
right?
correct.
And gotten their money by May or April and been on their way towards the November campaign. Is that correct? There's not any, like, you can't get any money until June 12th when everybody else has filed.
So there is a date before which no checks may be cut.
Which is what date?
It's the 142nd day. So in this election, for the November election, that was June 18th. So even if you qualified, even if you filed a qualifying request in May and it was approved, the check would not be cut until June 18th. And that typically is 5 days after the deadline for filing nomination papers. That's the 147th day before the election.
And then, I don't know how much experience you have with, we saw clearly some of these people are filing their qualifying contributions early and frankly going through the third and fourth rejection. Other people don't even know that they have to file a statement of participation. So is that what happens in other election cycles? I mean, you've been doing, the city, have been doing this for 14 years. Is that pretty common? Some people know the game and they're on it in February, and other people are figuring it out the day after they file for their candidacy?
I might let Leanne speak to that. She has a little
Okay.
bit more longitudinal history.
Longitudinal. That's a great way of saying old. Thank you, Pat.
Experience.
From my longitudinal experience, one thing I know from the city here is that since enactment of the public financing program, a number of the provisions and rules has actually changed fairly regularly. So I think there probably are some variety of experiences from year to year about how people file and by when they file. So this year, we do have a candidate who filed a statement of participation back in August of 2017. So they can actually file a statement indicating they would like to participate much earlier than when they decide that they want to run as a candidate. In essence, there's no starting time for when they have to do that. But I think it is also the case in other public financing programs that it really is very specific to the dynamics of that election and that particular district in any given year about when and how people decide to strategize about when to file their papers and whether they wait till the very last minute. Often incumbents wait to the very last minute because they want to see and size up the competition to see whether they want to participate. So I think often it's very unique to the political dynamics of a particular district to decide, for candidates to decide what they're going to do in terms of filing their papers. Is there another question that maybe I need to answer a little more clearly?
No, I'm just trying to get the dates in my mind. So the 147th date is the date for June 12th, that was filing that. And then the 70th is the one where they have to prove up that they have the $10,000 from San Francisco residents. And that comes in August sometime?
That's right. Yeah, that does fall in August for the November election.
And we're not going to have a meeting in August either, so we're probably going
That's
to have
right.
appeals in September for.
That remains to be seen.
All right, that's, I just, the lay of the land, I need to understand that.
But as I think about this, Pat, there is an advantage to filing, I mean, leaving aside campaign strategy, but there would be an advantage to filing early to get in your statement and to qualify, because the funds, once exhausted, are gone.
That's
for,
right.
For the appropriation for that year, so that if is that accurate?
Yeah, I mean, aside from just the value of having the money in hand up front,
Right.
that's always good. Right. I mean, the funds are available on a first come, first served basis, so that is possible. I think Andrew had a comment
could I
as well.
just add a little bit on that?
Mm-hmm.
So this is not really the place, I guess, necessarily to have a budget appropriation discussion.
Right.
But I really do think in the event that the election campaign fund ran dry, let's say during a campaign where there's a lot of candidates in the race or several races going on at the same time, I think practically the city would probably look at a supplemental appropriation that allows for additional funds to be put in. So I think legally it's theoretically possible, but I think practically I don't think that would be a huge disincentive. I think and this is just sort of based on my anecdotal experience, I think why people do want to submit their qualifying request early is for the reasons that Tony Kelly explained at the very beginning of today's meeting.
Right.
Just to make
time.
sure that
Right.
as soon as they can, they get the check in hand, and then they're off and running for the race.
Thank you.
So I think to elaborate or kind of approach this from a different way, we can look at it visually. So I'll do a kind of a graph here to show you the different phases. So as I mentioned, this is a little different for incumbents and non-incumbents. So I have them separated, non-incumbents on the left, incumbents on the right. And then the way that I'll display this for you is on the left for each kind of candidate, the funds that the candidate must raise through private contributions in order to qualify. And then beside that, to the right, the public funds that would become available to the candidate if they demonstrate these contributions. So again, here on the left in the box, those are the three phases. So at the bottom in blue, the qualification initial grant, then above that 2-to-1, above that 1-to-1. So we'll build it up. So the first level is your initial grant. You have to qualify a non-incumbent mayoral candidate, because again, this slide is just mayoral candidates. A non-incumbent mayoral candidate has to demonstrate raising $50,000 of qualifying contributions. I'll talk about what that is after this. As soon as that's done, you get $100,000. You can see for incumbents, it's a little different. You have to raise $75,000 of qualifying contributions to get that same $100,000 initial grant. And this is what the 2-to-1 phase looks like. So it's the same for incumbents and non-incumbents. For $425,000 of matching contributions, again, that's a defined term I'll talk about, you get $850,000 of public funds. That's the max. And then on top of that, you can see the 1-to-1 phase is relatively small. It's just $25,000 for non-incumbents and $12,500 for incumbents. Then here are the totals. So that would mean, let's just say that a candidate maxes out, gets everything out of the public financing program possible, which I believe we had 2 candidates in the June election who did that, 2 mayoral candidates. So that means that the candidate has demonstrated $500,000 of qualifying or matching contributions, and then in return has received $975,000. This is for a non-incumbent, which all those candidates were. You can see it's a little bit different than for incumbents. So you can look at this a little differently. If you put these together, you can see then what does that mean? What does a candidate have if they max out? This is the funds that a candidate would have if they max out. There's the $500,000 on the bottom, $975 of public funds on top. A little bit different for incumbents, but they both add up to the same amount. So that would be $1,475,000, and that's actually the amount of spending that candidates are limited to. This is, again, mayoral candidates. So that's where the spending cap is set. I'll come to that later, but just wanted to give you a preview here. That's what it's based on. It's based on candidates who max out on their public financing, how much money they would have. Right. So here's the same chart shown for supervisorial candidates. You can see it's the same model, same scheme, but the numbers are a little bit different. So the total for a non-incumbent supervisorial candidate in order to max out $95,000 of qualifying matching contributions, and then that candidate would get $155,000 of funds. So here's that same breakdown then of how much money they would be allowed to spend. $250,000. That's the spending cap for publicly financed supervisorial candidates based on the total amount of public funds they can get added to the amount of private contributions they need to raise in order to get that public money. So more on spending limits later. Okay, so now I want to move on to talk about what do candidates actually have to do in order to get public financing. I broke this down into the general 4 steps. There are basically 4 steps that candidates have to do. I'll go through each one individually, but they are laid out here sequentially, so they go from left to right in order. You know, as we learned, 2 and 3 don't necessarily have to be in order. You can file a qualifying request before a statement of participation, but this is done in the order that most candidates do it. Most candidates do, in fact, file the statement of participation first. So that's why I put that as 2. So you can see, so number 1, you open your campaign. Number 2, you file a statement of participation. Number 3, you file a qualifying request. Then if and when that's approved, then you may file matching requests. And you're not limited to just one. You can file multiple matching requests. Sorry. Okay, so I'll talk about opening the campaign. So there are a few steps involved with getting your campaign off the ground. The first one occurs at elections, not at ethics. That's to file your nominating papers and your declaration of candidacy 147 days before election. Again, that's not an ethics process, that's an election process, but I did just want to have a plug for that here. On ethics side, you're looking at the candidate intention statement, the Form 501. You have to file that before you raise or spend money. That's basically all that form says. I intend to raise or spend money. You open a committee bank account. There's a one bank account rule. You have to have your contributions going into that account and coming out. So you have to demonstrate that you have that bank account set up. And you have to set up your committee. That's by the statement of organization, the Form 410. And you file that within 10 days of receiving $2,000 in contribution. So there's a little bit of leeway there, but that's the trigger, is when you get $2,000 of contributions, you know, I need to form a committee now. So those are the steps involved with opening the campaign. Let's talk about the statement of participation. Again, doesn't have to be step 2, but most people do that as step 2. Statement of participation is the form SFEC 1.142A. The candidate is declaring his or her intention to participate in the public financing program, and the deadline is the 147th day before the election, unless it's extended, which we talked about in a previous agenda item. It can be extended pursuant to state law.
Is there some cutoff date when the Form 501 has to be filed?
Separate from just the trigger of raising or spending money.
Pardon me?
So the trigger, what requires you to have to file it, is if you're going to raise or spend any money. But you're asking, is there a date certain by which you must file it if you're going to file it at all?
I mean, you can file. You don't have to file that, do you? You can file to become a candidate.
That's right. Right. You can have a candidacy without filing the Form 501, right, but you may not raise or spend money.
You can't raise money unless you've done the 501.
Right. Exactly. Right. Exactly.
But you could do that 18 months before the election. I saw somewhere else as early as 18 months you could start raising money and that would get triggered.
Yeah, I believe that's right.
Going on to the statement of participation, which we heard a tremendous amount about, one of my questions is, one of the complaints is that the only way you can do it is online and your treasurer has to do it and you can only do it after you've done the other things to create a net file account. Is there any reason why we can't have that one form with that one piece of paper and give people the option of filing that by paper?
I mean, it theoretically is possible. It's definitely the intention of our office to move towards electronic filing. Just by and large, that is far more efficient, and in fact, most candidates do prefer that. You're correct that there is a little bit of upfront process required to establish your ability to electronically file. Basically, you have to set up the account, and you have to file a signature card, just verifying, here's a wet signature, this is me, this is my signature, and now from moving forward, now I can e-sign without a wet signature these forms.
So this is a dumb question. I'm assuming you have to have a net file account even if you're not getting public financing. Yes, no?
I believe that you do, because you do have to file other forms,
About where
campaign
you got
finance
the
forms.
money and not a contractor, et cetera. Okay. I just think, given the concern about people who are not politically sophisticated wanting to get a clue about the system is that and the other thing I was concerned about is this idea that only one person has that and it's the treasurer. That form that they're filing where they're attesting that they swear that they read the rules, they know what's going on. I mean, putting that in front of somebody and making them physically read it and sign their name may encourage them to figure out what it is that they just agreed to attest to. So it's just a thought as we go through how to avoid further hearings like the one we had today, if that would be an easy way to say, you had this option, there was a piece of paper there, you could have picked it up, or I want to think about that. Even though they would then still, maybe that they have to give you one of those in order to, when they set up their NetFile account, but.
And I also think that it was news to me today, not that I would have known this, but the requirement to set up a NetFile account, is an additional procedural step that needs to be taken. And it takes a little bit of time. You have to do the signature card. So whatever information we can provide up front that says, in order to do this, not only here's the deadline, but here are the 5 steps that you have to take to be able to e-file this format, because that's what we have right now. And that, is it a requirement to go into the office to be able to set up the NetFile account?
Yes, you do have to come in because you have to sign a
so
wet signature on a signature card to basically kind of establish your signature, quote unquote, for the program.
Right. So it would have to be done on during business hours, right? So someone couldn't sign up for your own online account on the weekend like you can for Amazon or something. You don't just need your email address.
Right. I think the thinking is, since these are legal forms, they're filings that are required by state law and local law, that we at least need them to have come in and signed a wet signature at some point.
Right.
That's kind of the thing.
No, I think that I'm not suggesting that we shouldn't do that. I'm just saying that if we are going to require it, I think making it more clear that it's not just, okay, the deadline is the same day as a deadline for candidate nomination papers, but there are steps that need to be taken and things you need to do, and that you can only accomplish during business hours. So you need to plan accordingly. So don't go to Department of Elections at 4:00 on the last day to file, and then expect to be able to also file for public financing at ethics within, by the deadline.
Definitely. No, point taken. And I think separate and apart from any potential legislative revisions that we might recommend as part of this review project, I think we can definitely look at just engagement and compliance stuff. How are we, engaging candidates and the public, and how are we informing them about this? Definitely. And obviously you don't need legislation to do that. So.
Right.
And if I could ask, is there any rules against putting signage up at the Department of Elections? So when people file for the candidacy, there's a visible area for them to know that, okay, these are the things that you need to do.
I don't believe there are rules against us having signage or brochures there. Is that correct, Mr. Shen?
Yeah, so I don't want to speak too much for the Department of Elections. I'm not sure if they would be that excited about having another department signs in their office, but I certainly think they would be open to passing out literature
Or make that available.
manuals or
Right,
materials of some sort when a candidate does file with them.
To one of the appellant's points, I thought I was doing everything that I was supposed to be doing, and I got all these packets of material, all this information. And if the implication being, if I had known that there was another set of forms I needed to fill out for the Ethics Commission, and if I could have gotten them at the same time that I filed the other set of forms, then I would have done that. So to the extent that we could, if not, at least have Department of Elections say, if you're here's some information, and then I'm not answer questions about it, but just at least give them access to the information, I think would be a good thing.
Yeah, I certainly think that's a possibility.
Okay. If there are any more questions about the statement of participation, I'll move on because this is pretty much it. There's the form, it's the deadline. Okay, so the qualifying request is where candidates actually demonstrate that they meet all the program requirements. So I'll go through briefly what the main program requirements are. So the first one is that the candidate is opposed by at least one candidate who has met a certain fundraising threshold. And it's different for mayoral and supervisorial candidates. But the idea is we don't want to give out public funds if there's one candidate in the race or one serious candidate. There has to be at least one opponent who has money. And then the requirement that I think most people think of when they think about qualifying for public financing is raising the required level of qualifying contributions. So for a non-incumbent mayoral candidate, I discussed this previously, it's $50,000, $75,000 for incumbents. For supervisorial candidates, $10,000 for non-incumbents, $15,000 for incumbents. And then here's roughly what a qualifying contribution is. It has to be between $10 and $100 in size. If someone,
is that a cap? It has to be $100 or less?
Right. So it's okay, though. Like, let's say that someone writes me a check for $500. It's okay for me to use 100 of those dollars as a qualifying contribution. It's not, the contribution itself is not excluded from being a qualifying contribution because it's over 100. I'm just limited to 100 of how much I can use on my qualifying request. And that's actually quite common. And that's built into the qualifying request. You can say what the total size of the contribution was and then how much you're designating for your request. So also these contributions must come from SF residents. Excludes immediate family, but basically someone from Napa or from Menlo Park writes you contribution, it's not going to be part of this program. It's not going to count. And then there's also a time window. You don't want someone fundraising for 10 years and then they finally meet the threshold. It has to be between 18 months and 70 days before the election. 18 months is just, that's the limit that's set. 70 days is because that's the last day to file your request. So obviously you can't use contributions you get after that day. Okay, so the next requirement, no outstanding filings or penalties to the city. You have to agree to comply with all the program rules. One of those is the spending cap.
If I could ask another question. For the residency requirement, is there a time limit?
Like how long they need to be a resident? I don't believe so.
The minimum time required?
I think the nexus is if they were a resident at the time they made the contribution. And that's part of the auditing process. When the auditors are reviewing qualifying and matching requests, they are looking at the supporting documentation that the candidate is providing that shows proof of residency. It could be a lease on an apartment. It could be a utility bill on your home. There's actually a whole list and regulations of different documents that you can use. Being a voter,
there's no minimum requirement that you need to be in that residence for months?
You could have just moved. And as long as you have something to prove that you are a resident, then it's okay.
But I thought we were going to talk more about that. So maybe as you're doing your review of the program and the effectiveness of the program, we heard a little bit, maybe it was from Tony Kelly, who's gone through the 3 or 4 rounds. We certainly heard a lot from the mayoral candidate Alioto about the difficulty of complying or finding those regulations. I mean, first let me ask, when I read the regulations, it seemed to me that if you were a registered voter in San Francisco, that it was fairly easy for you to cross-tab the name of the person who submitted the contribution. I don't know, do you do it or do they do it? Run it through the Department of Elections. If they show up as a registered voter, bing, they're automatically qualified, right? Is that, so one would think it wouldn't be that hard for somebody running for election to make sure that they were getting contributions from somebody that was actually eligible to vote for them. Is that, did I misunderstand that?
No, I think that's the idea. I think that someone being a registered voter is a proxy or sufficient proof.
Is just pro forma necessarily a San Francisco resident, already been validated by the elections department. Are most of the ones that are qualified, are the donors, are most of them validated by being registered to vote?
Yeah, I think that is the case. I think for the vast majority of that I've seen that they are. And then sometimes there have been questions when the auditors have observed that the name on the registration file indicates something different age-wise or address-wise than the name on the listed contributor. So they're looking for any discrepancies just to follow up with committees. But by and large, I think the voting rolls are the ones that are used to demonstrate residency and do so very easily.
Mm-hmm. Okay. I think, though, when you're having these meetings with the community, that's what you're going to hear about, just how hard it is to get back to somebody who gave you $20 and ask them to go pull their mail and give you a utility bill, et cetera, and it's in my roommate's name. To the extent that we can make that more clear at the outset, instead of, I know all the hard work that you do, going through their net filings and telling them this is missing and that's missing and this is a business address. But obviously it would save you all a lot of work and them a lot of grief if they knew when they were getting the money, get these things from the donor so you don't have to go back and so on. I want to really try and not have another hearing like that either.
Definitely. That's absolutely on my radar. There's a slide at the end giving a quick look at some of the major topics that we're looking at, and this is absolutely one of them. It's on the short list of high-level stuff. Okay, so this is the qualifying request, and then again, supporting documentation to show that you've met these requirements. The deadline for that, 70th day before the election. However, there are certain provisions that allow you to file a little bit after that if you're in a certain situation. So you can refile. That's if you withdraw a qualifying request and you file a new one. That you can do at any time before the 70th day before the election. And then resubmission. This is actually when you get a qualifying request denied. You can amend it to a certain extent and resubmit it within 5 days of it being denied. And through resubmission, it can actually result in you turning in a qualifying request after the 70th day before the election. However, there's a hard deadline of the 60th day before the election for qualifying requests.
So, Pat, on this point, because I think this was what was implicated in candidate Alioto's appeal before us a few months ago. And so I think that it would be incumbent upon us to be very clear in communicating what these deadlines are, what the 70th day is, and that also that the review process, if you do submit on the 70th day, the last possible time to resubmit would be the 60th day, but also the auditing team on the commission has to take the time to be able to go through the initial submission. And so what can end up happening is if you submit on the 70th day, that by the time you're notified of the rejection of your submission, there's not enough. There's very few small window left in order to correct the submission and refile by the 60th day. So I think that since we have so many candidates seeking public financing, and they have many have already 20-something have already qualified. By filing their notice of intent to participate. And as they submit their qualifying requests, I think it'll be really important for us to communicate to them that you do have up until the 70th day to submit to qualify, but there's a drop-dead date of the 60th day. So allow the time, because there are going to be so many candidates submitting, that the workload of reviewing all of the submissions and qualifying all of the contributions is going to be exponentially larger. That they need to allow themselves time for our review and then for their correction and resubmission.
And I would second that. I mean, I think that's a really good idea. Giving people, I don't agree at all that you are responsible for being their campaign treasurer and making sure they get their homework done on time. But I do think that under the circumstances, if we can send something out soon, because August is coming up, right? This deadlines are coming in August. If we can send something out soon that says, this is how it works, get your homework done.
Right,
I think
and
that would be helpful when we hear those appeals in September.
Knock on wood. Yeah.
Okay, so I'll go on to the next step in the process. I guess before I do that, I'll clarify here on the timeline. So the pink square here is us reviewing. So candidate submits a qualifying request, staff reviews it. If you're approved, you move on to the next step of matching requests. If you're denied, you go back and do another qualifying request. So you can do this step multiple times. But going on to the fourth step of the matching request, this is fairly similar to the qualifying requests. You're essentially submitting a list of contributions that you attest satisfy the different criteria, and you're asking for funds in exchange. So
do they have to be San Francisco residents?
They do. So a matching contribution must be from a San Francisco resident. Again, excludes family members. The same time window applies. So it has to be received between 18 months and 70 days before the election. And there's a minimum batch size. So I mentioned earlier, you can submit multiple matching requests. However, they do have to be a certain size. So you can't submit a matching request with 3 contributions on it. For mayoral candidates, your request has to be at least $5,000 in contributions. And for supervisorial candidates, $1,000. Then you can see there is a little bit of a lower standard in the last 2 weeks before the election. You could submit smaller batch sizes. The idea being, as candidates approach the election, things are a little more chaotic. It's okay for them to submit a smaller batch if they need to get a smaller amount of cash. It may be their last request also. But that's the matching request. And then the same thing is true here for qualifying requests. The pink square shows that staff is reviewing it. Although these aren't denied in the same way that qualifying requests are, there's a minimum threshold, right? For your qualifying request, you have to hit $10,000 or $50,000, depending on the office you're seeking. With matching requests, as long as you submit the minimum batch size, the auditors will review it. They likely won't approve all of the contributions, but the ones that they do approve will be matched. So your application, or I should say your request, won't be rejected, but certain contributions in the request may be rejected. And you can include those contributions in a future request. So let's say that you failed to demonstrate residency. Okay, you can go back, get a lease from that person, put that contribution in your next matching request. So they aren't reviewed in exactly the same way, but quite similar. And you can, again, continue to submit them. And you can actually submit them up until the 30th day after the election. So another filing doesn't really fit into the timeline, but it is a requirement, is the threshold forms. Essentially, you don't file these, you're not eligible for public financing, but it's not part of the requirements. You would not be eligible because this would become an outstanding filing. And I mentioned previously, if you have an outstanding filing owing to the city, then you're not eligible to participate in the program. But this is not exactly part of the qualification process. So what this is all candidates for mayor and supervisor have to report when they reach an initial threshold. For mayoral candidates, it's when they hit $50,000. Supervisorial candidates, it's when they hit $10,000. The purpose for this form, you'll recall when I was talking about what do you need to do in order to qualify for public financing, the first criterion was you have to be opposed by a candidate who's reached a certain fundraising threshold. This is how we know. This is how we know if there's a candidate in any race that has reached that minimum threshold. These correspond. So a mayoral candidate, in order to get public financing, has to be opposed by at least one opponent who has raised $50,000. This is how we know if there's an opponent out there who has raised $50,000. This isn't necessarily tied to public financing. Typically, this will be $50,000 in private contributions, but this is just how we keep tabs on that. So we can qualify or not qualify people based on it. And then if there is one or more publicly financed candidates in a race, like let's say District 3 race has one publicly financed candidate, then all candidates in that race have to engage in higher threshold filings. So, well, I used a mayoral example here, but for mayoral candidates, that is when you hit $1 million and then every increment of 50 beyond that. This goes into something I'll talk about in the next section, which is the spending limits. This is tied into how we adjust spending limits based on other candidates' fundraising. Okay, so I do have it here for supervisors as well. So when a supervisorial candidate hits $100,000, only if there is one or more publicly financed candidates in the race do you have to start filing threshold forms again. So you file at 100,000 and then every 10 beyond that. So 110, 120, 130, and so forth. And again, this is tied to the independent expenditure ceiling.
So, Pat, the filings then that say a mayoral candidate has to make is that when they either raise or spend $50,000, and then the next filing after that would be at $1 million.
That's right, and it's just raising the money. Or I take that back. No, it is expenditure, so it could be debt. I take that back because that is part of the IEC analysis as well. Right. So there's a huge gulf there. And it's because the different kinds of thresholds are serving different purposes. So the initial threshold, that's for letting us know whether or not we can start certifying people in that race. As soon as we get one of these, then we know, okay, District 3 is open for someone to qualify for public financing other than this one candidate, right? Because you can't raise $10,000 or $50,000 and then say, oh, I'm the candidate with $50,000, so I can get public financing. You have to have an opponent who has $50,000. So we'll know as soon as we get one of these, basically if there's anyone in the race that has that. Then the later, much higher thresholds, those are for a separate purpose. Those are for the independent expenditure ceiling. So it'll make more sense when we get to that, but basically this is how we track in more or less real time how much money candidates have so that we can adjust their opponents' spending limits.
Thank you.
So the spending limit is officially called the individual expenditure ceiling. Individual because each candidate has their own ceiling. There's not one ceiling that applies at one time to all candidates in the race. Initially it does. Everyone starts out at the same place, but as I'll explain, it is on a candidate by candidate basis. So mayoral candidates all start at $1,475,000. All supervisorial candidates start at $250,000. And you'll remember from the previous slides, that number is the sum of the maximum amount of public funds available to them under the program, added to the contributions that they would need to demonstrate in order to get that. So that's where that comes from. The idea being, if you're getting public financing, why should you be spending money outside of the money that you either got from the city or that you raised to get the money from the city? That's why it's set there. So here's to remind you that. So that's what it looks like. So this is where the $1,475,000 comes from. You can see the public funds in yellow, private funds in green. Same thing with supervisorial candidates. So raising the IEC is not a hard and fast fixed limit. It is adjustable, subject to a formula that's in the statute. So again, it's candidate by candidate. It's raised in increments. We don't fine tune it. It's not down to 50 cents. It goes in increments. $100,000 increments for mayoral candidates, $10,000 for supervisorial. This is a determination of the executive director, and it's based on a number of filings that basically enable us to track fundraising and spending. So it's based on the threshold form, which we talked about that earlier. This is why we have the higher threshold forms so that we can track candidate contributions and expenditures. Campaign statements, the 460. Obviously, these don't come out as frequently. Right now, there are only 2 pre-election statements. The ACAO is adding a 3rd one, but typically this is not exactly a real-time indicator of fundraising and spending, but we do look at it. IE reports, that's the Form 496. So independent expenditures for or against candidates are counted. That's part of the calculus here, so we look at those forms. And then also electioneering communications and member communications. Electioneering communications, similar to an IE, but there's not express advocacy. Member communications is self-explanatory. So I will go through how we do this. So the formula is based on 2 factors. 1, supportive funds of the candidate's best funded opponent, and secondly, opposition spending against the candidate. So I think this is the trickiest part. Get this, I think the rest will be easy. So this is done on a candidate by candidate basis. So you have to remember that we have one candidate in mind when we're looking at this. So the supportive funds here is not that candidate who we're analyzing. It's the candidate's best funded opponent. It's the opponent of that candidate who has the highest level of supportive funds. But when we're looking at opposition spending, that is opposition spending against the candidate that we're analyzing. So if you can keep that in mind, it makes the next couple slides make a little bit more sense. And then also I have an asterisk here just to remind you, done by increments. So it's not exactly equal, but you do round down. Okay, so the 2 factors, I'll break those down and show you what goes into each of these. So when we're looking at the supportive funds of a candidate, it's made up of different things. Generally speaking, it's money spent to support a candidate, or spent or raised to support a candidate. So that includes contributions raised by the candidate. So that's when we're looking at the candidate's 460. How much contribution money have they received? We're looking at the threshold form where they're telling us in real time how much money they're raising. We're looking at IE spending, supporting the candidate. This is supportive funds. And then likewise, electioneering communications and member communications in support of this candidate. So that's the first step. So if we're analyzing my IEC, look at all of my opponents and say, who has the highest level of supportive funds? Those 4 things added together. Identify who that candidate is. That's step 1. And see what that number is, that total. So step 2, opposition spending against me, against the candidate who you're analyzing. And that's IE spending. It's not spending by other candidates. It's only IEs. That one's a little bit more straightforward. You just look at the Form 496 typically. So I'll put that up again. So supportive funds, best funded candidate, best funded opponent, plus opposition spending against that candidate. Let's look at an example. So we will analyze the IEC for candidate 1. You have to have an opponent, so here's candidate 2. These are both supervisorial candidates, so they start out with an IEC of $250,000. It only gets raised through campaign activity. So here's some campaign activity. So we're going to look at candidate 1's opponent, so that's candidate 2. Let's say that candidate 2 raises $200,000. Discloses that on a threshold form or on a 460. Then an IE group spends $85,000 supporting candidate 2. Let's say we're in the late reporting period, 90 days before the election. That IE group files a Form 496. The next day, we find out about it. We calculate this, and we say, okay, candidate 2 has total supportive funds of $285,000. Step 2, you need to find out what's the total opposition spending against candidate 1. We're analyzing candidate 1. Let's say an IE group spends $20,000 opposing candidate 1. Same thing. We'll find out about that on a 496 if it's within the late reporting period. $20,000 is the opposition spending against candidate 1. You add those 2 figures, and it gives you $305,000. That is well over $250,000. So an IEC adjustment for candidate 1 is warranted. So the executive director would make that determination and adjust the IEC. So $250,000 is gone. It's $300,000. Why is it $300,000? Because you round down to the nearest whole increment of $10,000 for supervisorial candidates. We don't do it to the dollar, to the cent. It's always rounded down. So in this case, $305,000 gets rounded down to $300,000. That's now candidate 1's IEC. So a press release would go out. The candidate would find out. Now the candidate may make qualified campaign expenditures up to $300,000. That was a lot. Are there any questions about that I can clarify? No. Okay.
Well,
I'm sure there will be later.
I'm sure there will be later, but just if I recall the last mayor's race, the campaign, the expenditure ceiling it kept getting raised. I don't know how many times it was. It must have been at least 25, 30 times between the three candidates. And so I'd love to get your thoughts as well as input from the public on, I think it serves an important purpose, but is there a better way, easier way to accomplish the goal, right, without having, because it seems like there's a press release every morning and afternoon.
No, that question is absolutely on the short list of major questions for this project of looking at. Absolutely. I'll say one thing on that topic, which is that you do have to decide if you're going to raise IECs, you have to decide if it's going to be based on candidate spending or candidate fundraising. You have to look at one or the other. Our system looks at candidate fundraising instead of candidate spending. So one effect of that is that when you're looking at candidate fundraising, the candidates don't have to spend the money in order for it to be counted as supportive funds for them. So in this scenario, it says candidate 2 raises $200,000. Candidate 2 doesn't have to spend any of it in order for it to raise candidate 1 IEC. So this was part of the confusion in the election, is there wasn't candidate spending necessarily going on that was raising the IECs of other candidates. It was just candidate fundraising. So this caused some confusion as well. But the alternative is you base it on candidate spending, which means candidate 1's IEC doesn't get raised until candidate 2 spends that money, which means candidate 2 can be sitting on a big pile of cash and candidate 1 is tied down, and then candidate 2 can spend it all at once. And then it takes the Ethics Commission a little bit of time to get the filings in and raise the IEC. So I suspect that was the policy judgment made by whoever created this law. But generally, you do have to choose between one model. So,
got it.
So to wrap this up, next steps, policy is doing an in-depth review of this program. That's the statutes, the regulations, outcomes, looking at data about recent elections, and going to talk to candidates, talk to treasurers who have participated in the program or who haven't, who have chosen not to or weren't able to qualify. I'll be talking to the public. We have 2 interested persons meetings that are coming up. One is on July 31st. The other is on August 1st. Those are actually dual purpose meetings. We'll be talking about public financing and the next agenda item, which is the opinion and advice regulations. So this will be an opportunity to hear from people about what they perceive to be the pros and cons of the system as it's set up. So some questions we'll be asking: is it effective? Looking at other jurisdictions, Seattle, there's a lot of talk about Seattle. So we're definitely going to look at Seattle. And whether or not public funds are misused. That's definitely important, is that, as we heard earlier today, these are public funds. There are laws in place to safeguard them. So we'll be looking at whether or not there are sufficient laws in place to make sure that candidates use them in the appropriate way. So I will skip this in the interest of time, but I do want to just point out these 3 bullet points down at the very bottom. I mentioned before our kind of major questions at the beginning. Is the application process good? Is it letting in too many people, not enough people? Is it based on the right rules? Is it administered correctly? And then the kind of funding candidates get. And then lastly, the IEC. Is it set up correctly? Here's 2 resources. This is more for people watching this at home that want to learn more. The supplemental guide, the website. Those are the best places to go. Don't go to the code. Okay. That concludes the presentation.
Thank you, Pat. I think this is a really helpful overview, and it's certainly very timely and important topic that I'm glad that we are prioritizing in the upcoming months, and look forward to the interested persons meetings. Hopefully they'll be well attended, and welcome feedback from all stakeholders, and look forward to how you're going to synthesize this and next steps. Public comment? Item.
I'll try to snap two here and be quick. I just wanted to give you a quick overview of my involvement and what I've seen in the last 20-some years. I was called by Common Cause to pick up a gauntlet and put the CFRO through the Board of Supervisors in 1995. That was introduced by Elizabeth Lamb of Common Cause to Supervisor Hallinan. It was a expenditure limit coupled with a variable contribution concept that actually came out of Oakland. And it was passed by the board, vetoed by the mayor, that was Mayor Frank Jordan at the time, placed on the ballot by 4 supervisors, and I headed the steering committee for the campaign, and it passed overwhelmingly in '95, in November. In 1999, it was challenged by Clint Riley and I believe also Mayor Brown in 2 lawsuits in federal district court, with Judge Claudia Wilkin issuing a decision, and that decision had a footnote that said public financing is probably your only option, as she overturned our CFRO and our variable contribution limit system. So in any event, it was a wise decision. We had no objection on that. So Tom Amiano, at Common Cause's request, asked the Ethics Commission to draft public financing legislation and basically a rewrite of the CFRO, which we did, and it was rejected by the board 10 to 1. And obviously the commission responded extremely well by placing the measure on the ballot as Prop O. And that's our law today, with a legislative supermajority passage of the extension of public financing to the mayoral system of campaign finance. So I just wanted to say there's 3 things that I've seen. One is that PF is a platform for debate and not to level the playing field. Leveling playing field is unconstitutional. Platform debate or debate is very cool. Check and balance on political corruption. That is a mechanism I could get into, but I won't. It's not happened yet. I'm waiting for the day. But there is a check and balance mechanism aspect to this, and I think it's important and historic. And the term independent expenditure commission or committees prejudges the independence of the committee, so they should be called non-candidate contribution or non-candidate controlled committees. So I hope you understand that last point. That recommendation comes from Bob Stern. Thank you.
Thank you.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. First, I just wanted to say I thought the presentation was excellent. Second, as part of the application process for public financing, to avoid the application crisis that we saw today at the hearing, I think it's important to have one-stop shopping, whether or not everyone picks up their packet at the elections department or the ethics commission. Everything should be in one place to avoid what happened today. Thank you.
Thank you. Okay. Agenda item number 8, informational staff presentation and overview of draft Ethics Commission advice and opinion regulations.
Well, before we leave that, I want to ask Ms. Pelham a question.
Sure, Commissioner Cotton.
The last witness's testimony, I think, is obvious to everybody still here or watching on television, but Is there some encumbrance, legal or social, to posting signs in the Department of Elections saying that if you want to qualify for public financing, proceed to whatever our room number will be when the remodeling finishes?
I don't know that there is, but I would agree with Ms. Mayo's comments that we actually should do more than that, and we should have a one-stop shopping
Well,
concept.
All you have to do is put up a couple signs.
We could do
The
that.
Elections.
My experience tells me it's
Department. That's easier than, I don't know how many people are working there, but it's easier than telling all those people to make sure to tell candidates. That's how they can qualify. Anyway.
My thought to share with you all is that it would be helpful to have even have commission staff who can work remotely on laptops be at the elections department during candidate filing periods to be able to make sure they get information in their hands timely. So there are a lot of things I think we can do to respond to some of the concerns we've been hearing and that we know we would like to be more assertive being out there.
I definitely would like staff to explore that, and hopefully we'll get some feedback from the public during interested persons meetings. And then when we come back to this topic at a future meeting, would like to hear, specifically about what we can do both in the short term as well as the medium and the longer term.
And I have one really quick comment. I was doing the math on the 70 days and the 60 days, and it looks like the 70th day is around August 28th. The 60th day is around September 7th. And there's no way that you're going to have there's no meeting until September, which is well past. So going back to the point about coming out of this, giving people a heads up to not wait until August 27th to submit, I think is really going to be important, hopefully, to avoid people feeling the necessity of appealing, because we're not going to be able to accommodate them. I don't know about anybody else, but I, for one, am out of town for Labor Day week, so if you are going to have an appeal hearing there, just know that you guys are on deck for that. Just big, bold, don't wait.
Thank you. Agenda item 8, Pat?
Thank you, Chair Chu. So agenda item 8 is the initial presentation of a set of draft regulations that pertain to the Commission's opinion and advice giving processes. So under the city charter, anyone may ask about how the law applies to their personal situation. Basically, you can inquire about whether or not certain conduct, if you did that, would constitute a violation. And there are two general ways that you ask, and they correspond to two general ways that questions are answered. One is through informal advice provided by staff. This is by far the most common. Probably 99% of questions are answered in this way. People call, or they email, or they come into the office, and they ask a question about how the law applies to them. Staff provides them an informal answer that does not carry any immunity if they later were to become the subject of an enforcement action. Separately, there's a process whereby people can request an opinion of the commission. So this is when they make a formal request, staff drafts a proposed opinion, commission evaluates it, and you vote on it. And then the city attorney and the district attorney will evaluate it, decide whether they concur. If they concur, then that person essentially has immunity to the extent that if they comply with the recommendations in the opinion, and if they have provided all the facts are true, and they stay within those facts, that essentially the probable cause will not be found to exist if they do engage in that conduct. In other words, they wouldn't be subject to an enforcement proceeding. So those, in a nutshell, are the two separate channels that the charter creates for people to inquire about their duties and obligations under the code. But that's about the extent of what the charter says. It doesn't tell people how they request these things. It doesn't really explicitly tell them what the legal effects are of these kinds of guidance. And it doesn't tell them more specifically what the proper subject matter of a request is. So it's important that these things be clarified for people in a standardized way, and regulation, staff believes, is the best way to do that. So the attachment to this memo is a set of draft regulations. For purposes of this meeting, this is just to tee it up basically for potential future action at a future meeting, not today. But I just wanted this to be in front of you and in front of the public so that people can look at it, see what's in here, and we can talk about this at a later time. As I mentioned earlier, there are 2 interested persons meetings scheduled to discuss the public financing program, but also these regulations. So again, that's July 31st, 2:15 p.m., 25 South Van Ness, room 70, and then the same location following day, August 1st, and that will be at 4:15 p.m. So those meetings will be to get reactions from the public and further ideas about these advice regulations. And then I hope that the commission will schedule at a future meeting a time to take these up and potentially to approve them so that these can actually be enforced and guide people. So that basically is what's in front of you. Any questions?
Yeah, Commissioner Rennie.
I'm just curious, why do you have it go on the, we're talking about opinion, why do you have the opinion go and get the commission agrees on it, then send it to the city attorney to ask him whether or not he agrees, and then it comes back? Why doesn't it go to the city attorney before it ever comes to the commission?
So I think in practice, we typically do consult with the city attorney before staff submits our official recommended opinion to the commission. We are talking with Mr. Shen or Mr. Gibner about that. So when they get an approved opinion from the commission, it's not the first time they've laid eyes on it. So in theory, they have had a chance to weigh in on it.
But the way you have it drafted is it gets to the commission. You may have sent it off to the city attorney, but you then send it off to the city attorney after the commission accepts it, for the city attorney to come back and say, it just seemed to me a step that ought to be before it comes to the commission.
Right. No, point taken, and that order is formalized in the charter. That's actually in the ethics provisions in the city charter, that's the order. And it even has timing provisions of how many days staff have to send the opinion, and then how many days the city attorney has to decide whether or not he concurs in it.
But the language, if I may, through the chair, the language in your report says the charter requires within 10 days of receipt of the proposed opinion. So are you saying that the commission, when we, quote, adopt an opinion on the recommendation of staff, that's just a proposed opinion until the DA or the city attorney review it?
So the legal status of an opinion that the commission adopts, but which has not yet or never gets concurred in by the city attorney or the district attorney or both, is unclear. It doesn't say in the charter exactly what happens there. So that I will turn over to Andrew.
Yeah, I mean, just to be clear, so in the hypothetical scenario where the different agencies do disagree, only those bodies that agreed with the conclusion of the opinion would be will have essentially bound their hands in terms of any subsequent enforcement action. So for example, let's say the Ethics Commission adopts an opinion, makes it a formal opinion of the commission. Let's say the city attorney's office concurs. Those 2 agencies have bound themselves in terms of future enforcement actions based on the circumstances provided in the opinion. So the Ethics Commission couldn't initiate its administrative enforcement. The city attorney's office couldn't initiate a civil action. But let's say the DA's office disagrees. They simply just do not agree with the conclusion of the opinion. They could theoretically still exercise their discretion, at their discretion, to initiate a criminal action based on whatever is described in the subject matter of the opinion.
Okay. Too late for all those hypotheticals, but thanks for answering my question.
So, and that was actually something that these regulations seek to clarify, because it's a very good question. And these regulations would make it so that effectively, as long as the commission adopted opinion, that person would not be subject to an enforcement proceeding at the commission level.
Right, enforcement proceeding vis-a-vis the commission.
Exactly,
Okay.
exactly.
Thank you. Any other questions? Public comment?
I've got to get wife is leaving.
Leaving? My ferry leaves shortly, so I got to leave here at 7:30.
We'll still have a quorum, though. All right. Ms. Mayo?
Yes. Anita Mayo again from Pillsbury, Winthrop, Shaw, Pittman. I'm just going to refer to each of the sections that are listed in the regs, the proposed regs. So the first one, section 12A2, a subparagraph A provides that upon receiving a request for an opinion, the executive director or designee will determine whether the request constitutes a complete and proper request and transmit that determination to the requester as soon as practicable after the determination is made. Similar to the regulations promulgated by the FPPC, the regulation should instead provide a specific time frame for the notification to the requester. Regarding Section 12A3, the executive director will not make a finding of probable cause against a respondent who was the subject of an opinion adopted by the commission in which both the DA and city attorney were in concurrence. But a finding of no probable cause by the executive director should also apply even in the absence of a concurrence by the district attorney and or city attorney. Section 12B1, this regulation will prevent any person, including attorneys, from seeking informal advice regarding hypothetical situations or general questions about the interpretation or policies regarding the city's political laws, unless the advice pertains to the requester's duties. This will significantly and negatively impact attorneys who seek to understand these laws so that we may properly advise our clients regarding the same. This position is contrary to Section 1.168D of the Campaign Finance Reform Act, which specifically provides that any person may request advice from the Ethics Commission or city attorney with respect to any provision of this chapter. This provision is also contrary to a similar provision in the FPPC regulations. In Regulation 18329C, informal assistance may be requested in part by 1, any person whose duties under the Act are in question, or by that person's authorized representative, or 2, any person with a duty to advise other persons relating to their duties or actions under the Act. The FPPC thus recognizes the value of providing informal advice to attorneys regarding various laws under this jurisdiction. I recommend that the Commission adopt the approach used by the FPPC, which includes 3 methods for providing opinions and advice: formal opinions, formal written advice, and informal assistance. And finally, Section 12B2, which is similar to 12A2, a specific time frame should be provided for the executive director to notify a requester whether or not the request for informal advice is complete and proper, instead of as soon as practicable after the determination is made. Thank you. And I look forward to the interested persons' meetings.
Thank you. Charlie, any other front? Okay, great. Agenda item number 9, discussion of the monthly staff policy report.
Thank you, Chair Chu. I'll make this very brief. So I've divided this into 2 general categories. One, ongoing policy initiatives, and then secondly, what I would call administrative projects. I think that more or less reflects the dual purpose of the policy division to help the commission execute its policy agenda, and then to also serve sort of a general program administration and advising role. So under ongoing initiatives, A, B, and C reflect what the commission determined to be its top 3 policy prerogatives at the last meeting based on the policy prioritization plan. So number 1 is a review of the public financing system. I think agenda item 7 tonight has taken most of my bandwidth on the public financing reviews. I've been focused on that, of producing that and using that as a launch pad for the future review. Secondly, the campaign finance reform ordinance regulations. So this would be a review project essentially to update the regulations, see if there's anything that's now out of sync with the code, create regulations to implement the ACAO, et cetera. So that program is just getting started. And then thirdly, looking at online political communications. This is something that right now staff is trying to learn as much about as possible, reaching out to other jurisdictions, keeping apprised of big stories that are occurring across the country. It's an area where there's a lot of action. Things are changing quickly. So basically just trying to keep informed about this right now. Then the second category, more to sort of kind of miscellaneous projects. Advice regulations. This is sort of a leftover item from previous commission direction. We just discussed that as agenda item 8, upcoming IP meetings and a draft for you to look at. Implementing the ACAO, I've been involved with trying to make communications to the regulated community to let them know what their new duties are under this law. Specifically on July 2nd, we sent out an email notice to all board and commission members and a separate one to all elected officers, letting them know about new restrictions that apply under that law. And then also answering questions that are coming in. And I know Andrew's been doing a lot of this as well. A lot of people are asking questions to the city attorney's office. And then the biennial conflict of interest code review. Every 2 years, city departments have to look again at their rules, their Form 700 rules, and see if the list of people who need to file Form 700s in their department needs to be updated. So that's something that we advise on since it has to do with the conflict of interest code. And then Section D, just a quick update on different pieces of legislation locally that we're tracking. The first one is the whistleblower ordinance. This is now pending at the Rules Committee. We're still trying to get a hearing. What has happened is that the sponsor was elected mayor, so it has been hard to get in touch with her and her office, understandably. She's been incredibly busy. So it's unclear right now if someone else may take that over for her or if she may continue to be the sponsor of that. So we are working on that. And we'll be working with Supervisor Safai, who is the chair of the Rules Committee, to see if he has understanding of what the status is here. And then secondly, the ordinance sponsored by Supervisor Cohen that would create financial disclosures for candidates in what I'm calling trustee elections, 3 different kinds of elections that are listed here. We learned today was formally scheduled to be heard at Rules on July 25th. So I will be there, and I think we have a little bit of feedback still to give, but more or less this draft of the ordinance is responsive to our past comments. Number 3 is sort of a omnibus ordinance that Supervisor Kim is sponsoring. And that one, like the whistleblower ordinance, is pending before Rules. Rules has not acted on it. We're not clear exactly if and when that's going to happen, but I am tracking that. And then lastly, this one was referred to us, but it's not clear that there's a direct implication for ethics. This is the Privacy First initiative that would be a charter amendment sponsored by Supervisor Peskin. The only potential impact that we see right now is that it could affect the way that our contractor NetFile is required to administer private information that they collect as part of their system that they use to administer our electronic filings. So once we have a clearer picture, this is kind of in flux right now, but once we have a clearer picture of exactly what these new data protection rules would look like, we'll be able to look at what NetFile does and see the degree of that impact.
The only thing I would add to that, and it may not be germane to this ordinance as proposed by Supervisor Peskin, and that would be the donor information that's included in the qualifying requests that end up on appeal and are included in all of our packets and sent out to the public. And so that's like home addresses of people who may or may not expect to have their information that they donated to a particular campaign and that are included in this, through no fault of their own in the materials that disseminated as part of the process. So I just would like to ask you and staff to think about that as we look at Supervisor Peskin's ordinance, but also as we look at our own practices and procedures with the public financing program. Okay, thank you. Public comment? Comment, all right. Moving right along. Agenda item number 11, discussion of the Executive Director's Report.
Thank you, Commissioners. I will be brief as well, but I have 2 very important items that I would like to share with you and those listening, and that is that I'm very, very pleased to Excuse me. I'm very pleased to let you know that I have appointed Gayatri Taikandil as our permanent deputy director, along with her duties as chief programs officer. She's here this evening. Gayatri, as you know, was with us starting 2 years ago as a FUSE executive fellow. She worked with our office through the program administered by the mayor's office. We were very lucky to have her at that time in a consultative capacity to help us think through using online technology to really try and get information in the hands of the public in a way that they need it, when they want it, how they want it, and the same with the regulated community to try and improve understanding of our laws and compliance with our laws. And Gayatri was so delighted to stay with us now on a permanent basis last year as Chief Programs Officer, taking over primary leadership for the strategy and mentorship of our engagement and compliance team. And I think, as you will no doubt see, as our programs and processes continue to improve and strengthen, Gayatri's had a very strong hand in doing that and achieving that in the past year. I'm delighted that going forward now on the basis of being our permanent deputy director and chief programs officer, that she will be very much instrumental on all aspects of our operations and programs, and to improve how we approach our work, focused on budget and focused on performance and focused on just really supporting a terrific engagement and compliance team as it continues to grow. So with that, I just wanted to welcome officially Gayatri as our Deputy Director. I'm delighted to have her here. Also, in that vein, I mentioned...
Before you, I just wanted to interject and say congratulations, Gayatri, and I look forward to working with you, and I think that it's... you're perfectly placed at the right time in the right place, where we need your skill and strategy and vision to help us better communicate what it is that we do, how we do it, and then inform people, just as we heard at length today about how challenging the process is for people to access a public financing program. So I look forward to your efforts and contributions to helping us get better at it.
Thank you for that. And lastly, in terms of our other hiring plan progress, we have made significant progress in the last several weeks and have now, I think all but one of the positions have been referred over to DHR, to Department of Human Resources, in final draft form to get some feedback. But we have a senior information systems position that is going into the oral exam phase next week. We have applications that closed last week for the Director of Enforcement and Legal Affairs, so there should be more progress to report soon on that. And two principal program managers, one for audits as well as one for engagement and compliance. Those have been wrapped up and sent over as well. And we are working to finalize a senior program analyst for engagement and compliance. And even though tonight was the Pat Ford show and we all very much enjoyed it, and his longitude is increasing as we speak, we are also going to be posting for a policy analyst so that he has a little bit of help on occasion to get through all of the work that you see before our policy team. So there is progress. I'm very happy. It's been slow. There's been a lot that we've been juggling, but I'm very excited about the prospect and look forward to reporting more news to you at your September meeting about the status of positions and where we are. Happy to answer any questions.
Just two questions quickly. One is on ACAO in terms of the funding. That is now going to have to come out of salary savings, not through the budgeting add-back process through
That's
the
correct.
mayor's office. And do we have the bandwidth to be able to absorb that?
We're going to have to, yes. Part of it is we do have salary savings that we're going to tap. We've done some calculations. We've also done a very rigorous assessment of what we can establish and the technology we could use to try and get to these new disclosures. And so I think we're going to manage as best we can to get that the systems up and running as soon as we can with salary savings. We don't really have another option. So I think we can make that happen.
Maybe some of the campaign finance fines of $82,000 this past year. And then my, what was my second question? Okay, I forgot my second question, so we can take public comment.
Just to make, Charlie Marsteller again, just to make sure the public understands that enforcement actions, the funds that we collect from those actions do not accrue to the commission. They are to the general fund. So the public should definitely be aware of the proper mechanism which we've put in place for those funds. And pardon my hoarseness, I get this way at the end of the day. I did have a point to make, but now I think I've forgotten it. I know, aphasia. I think we owe the mayor some type of response. This, I assume, is Mr. Farrell, the recently departed mayor, for his support of our budget. I think it came basically through his office and then went to the board. So as he departs, I think we should acknowledge with some thanks his support for our budget, which is our requests have been robust, and the city has met our needs. And I'm really appreciative. I cannot impart to you how far we have come since 1995, when we started, with 3 people. And it stayed at 3 people and maybe went to 5 people for the next almost, I don't know, it seemed like forever. Certainly till Mr. Newsom came in and the Reform Board came in and started building a budget, finally, for the commission, almost 10 years after we got started under the charter. So I did want to, and that was in 1995, early in 95. So I did want to mention that, and I wanted to say that certainly this member of the public is appreciative to the former mayor, just recently departed, for his support of the Ethics Commission.
Thank you, Charlie. You make a great point. I think certainly during my tenure here, Mayor Lee was very supportive of the commission in terms of expanding staff and giving us additional headcount to be able to fulfill the mandate of the people, and also to deliver on the strategy and the programs and results that we're all seeking. And then certainly interim Mayor Farrell, the same thing, in a year when other departments were uniformly asked to cut, and for us, cuts would be just people, because we don't have income or other things, and so his support has been really instrumental. And I hope that our current mayor will continue to support us in the next budget season as we go forward. Thank you. Okay, agenda item number 12: discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. Possible closed session. We just take public comment on that? I don't know that there's
Right, the commission's not required to go into closed session if it doesn't wish to
Okay.
do so, but we still need to take public comment.
Okay. Public comment? No public comment. Is there any desire to go into closed session? Okay. We'll not go into closed session. Okay, agenda item number 13: discussion and possible action on items for future meetings.
This is yours?
This was handouts.
Anything from commissioners? Any public comment? No.
I don't want them.
14, additional opportunity for public comment on matters appearing or not appearing on the agenda pursuant to Ethics Commission Bylaws, Article 7, Section 2. Mr. Marstello.
I would again appeal to the commission for consideration of a mechanism for the public to signal questions, either electronically or through telephone or something. As members of FOE are getting apparently old and decrepit, we've had health setbacks for several of our members that are severe, so that they're not mobile or able-bodied and no longer able really to get here. So that is of concern to me, because I know they have questions and they have points to make. So if you could look at that issue, maybe that's something we could set up so that Mr. Bush or Mr. Planthold, a former commission chair, or other people, former commissioners who are now aged, can call in or email us questions or points that they would like to make.
Thank you. Motion to adjourn?
Actually, I was going to.
Oh, yeah, please, Commissioner Lee.
I really agree with Charlie's point. Is it possible for them to email the director the comments or questions during the meeting? Because your email is a government email account.
it is technically possible for anybody to email me or any of you all at any time at our SF.gov email addresses. We, as you know from today, for example, receive emails up on almost until the time of the meeting, and we do provide them to the commission and make copies for the public.
Right.
I think it is difficult to immediately know how we would mediate or moderate those incoming communications during a live meeting while it's progressing. That would have to take some considerable planning and rigor to make sure that the public is aware of what information is coming in. I think there is no shortage of communication, certainly at this point, of the public communicating up until the very meeting start, for sure.
Great. Okay. So a move to adjourn?
Adjourn.
Second? All right. We're adjourned.